Twice you're also adjournment. Why are you asking for adjournment every time?
No, Mr. Das is some personal difficulty. Hmm. 1 week after.
See, in my court, it has come on 31st October, you took adjournment. Thereafter, 26th February, you took adjournment. 18th March, again you took adjournment. And 18th April, again you took adjournment. And 10th April, again you took adjournment.
Counter
And now
measure.
again, 1, 2, 3, 4, 5. 6 times you have taken it. And there is an interim order operating.
Personal difficulty, maybe taken a 1 week after matter.
Six time it
last,
can't be.
last.
See, from August 2023 till today, the personal difficulty only. There is some limit. 1 accommodation, 2 accommodation, I can understand. You can't ask for
Last time, personal difficulty.
This matter has been listed before this court on the special assignment. The matter was listed earlier. 1, 2, 3, 4, 5, 6 times. On every occasion, the land counsel for the petitioners seeks an adjournment. Even today, one more opportunity is one more adjournment is sought. An interim order is operating in this matter against the respondent. Therefore, I'm not inclined to grant adjournment. However, by way of last opportunity and in the interest of justice, the matter is adjourned to next week. And it is made clear that if the matter is not argued next time,
maybe take no next week, last time.
The interim order passed earlier shall automatically stand vacant.
My lord, item 73, I pray for adjournment. It was directed, your lordship directed the petition number 2 and 3 to present in person, but I could not intimate it, so.
Yes.
My lord, item 74.
74, what happened?
My lord, it is a matter relating to the dispute of husband and wife, my lord. Both are present. May I pray for kindly
I'll take it up
with
with 12 o'clock. Yes.
Item 132 of full list for hearing, my lord. Vigilance case, my lord. The informant.
You know, one after 2 o'clock, if the board is exhausted, I'll take it up. Yes.
Well, item 12 and 13, bring next week, my lord.
Why?
No, senior not will, bring next week.
12 and
13. Any date, right?
Bail matters you are asking.
My lord.
It will go to September only. No question of
Next week, any date, my lord.
September. Yes, 12 and 13.
12 and 13. Oh, bless me.
September. Yes.
My lord of mentioning out of the list, Lord, 6 years 2022 matter. Out of the list,
Bail matter.
TRLMC 2022 matter.
22. Huh? But what 22 matters are not listed. Yes. Any bail matter anybody is asking for adjournment, keep it in. Request of land counsel.
Pardon, Lordship, item 74, Lordship.
70.
74.
74, yes.
Lordship, kindly taken over 2 p.m. The matter was amicable settled between both of the parties, Lordship.
Bring them, we'll see. What is the offense?
Lordship, 498, 307. Obliged, Lordship.
Yes. Any mentioning online?
Pardon to mention, Millards, item number 88. In 88, we will file fresh colored nama in that case, Millards. So I'm seeking for an adjournment in 88 so that it will take proper.
For the petitioners, which is taken on the court. File is there, you can take it in the court. Take it in the court. List after. Yes.
Millards, our name may kindly be.
Name shall be.
Grateful, Millards.
Yes, next.
Item 1.
My lord, item 1, my lord, I pray kindly pass over.
Pass over, okay. Item two,
Washing of welfare, my lord.
yes,
Can you have a glance? Order dated 23/7/2023, my lord. But this honorable court has.
anticipatory rejected.
My lord.
Anticipatory bill rejected or not?
Anticipated bail, no, my lord. The order is relating to some other direction that whether the statement has been recorded before the special court Baleswar or not. Both are living together, my lord. They are also blessed with a child. So lordship fix up a date, then both parties will be appear, my lord.
No, what is, also is there? Appeal
That is
will
why
not-
the court has directed, my lord.
They are married. Are
My
they
lord.
married?
My lord.
There is a child.
There is a child, my lord.
What is the age of this girl now?
Age of the girl is, my lord, 21 years, my lord. Under the date of occurrence, it was 19, my lord.
19. What is the age of the boy?
Boy was a major, my lord.
I know major, but I am asking major,
25
obviously
years, my
major,
lord. 25 years old, my lord.
25 years. So bring them, we'll see.
Lordship, I pray for a date, specific date, my lord, so that they
No,
can.
specific date.
Oblige.
Legal counsel for the petitioner submits that the parties, the petitioner and party number, where is that victim? You have not included the victim.
Already appeared, somebody.
No,
One.
that is Ramesh Chandra Manna, the father.
Father.
Victim also included because he is now major.
Well, by that time, it's considered
But
that.
now you just, I'm talking about now.
Yes, sir, press
Legal
notice.
counsel for the petitioner submits that he would implead the victim in the present case as the opposite party number 3, opposite party number 3. He further submits that the parties have settled their dispute and petitioner has married with the opposite party, newly impleaded opposite party number 3. There is a girl or boy.
Boy, my lord.
They are blessed with male child, male child. Leave the matter. Item 3.
Please, your lords. My lord, here the petitioner has come before this honorable court, assailing the order dated 17/11/2023, passed by the Learned Appellate Court, Additional Sessions of Khurda, that with regards to the amount, my lord, the Learned Court below, trial court, convicted the petitioner, and my lord, page 25.
Yes.
And hence, this court sentenced the convict to undergo simply.
That is the statutory requirement, 20%.
My lord, my lord, my small prayer is 20% of the check amount. My lord,
20% of the check amount at the 143 capital A. Once you are
my lord.
convicted, then 20% of the
My lord,
compensation amount.
my the Learned Appellate Court has passed the order that is for the 143A, with the 20% of the
143 is all right. I am talking about 148 capital A after conviction.
my lord.
Then after conviction, compensation amount for 20%. At the initial stage, it is 143.
My lord.
That is the check amount 20%. Afterward, you are convicted, the compensation is awarded to the complainant. 20% of the compensation amount you have to. Your deposit.
My lord.
The petition. I'm dismissing it.
My lord.
I can't help it. This is the law. What to do? I can't change the law. Petitioner is agreed by the order dated
But one thing, my lord.
17/11/2023, whereby the trial court has directed the petitioner to deposit 20% of the compensation amount awarded by the trial court after convicting the petitioner for offence under section 138 NI Act. As per the provisions of section 148 capital A of NI Act, this is the mandate. The mandate of law is that the convict is required to deposit 20% of compensation amount by the court, trial court, while convicting the petitioner, convict the accused under section 138 NI. I find no infirmity in this matter. Therefore, I am not inclined to entertain this petition. However, however, the petitioner may apply to the appellate court in the pending appeal if he seeks to deposit the compensation amount on installment basis. If such application is moved, same shall be considered on its own merit. You can move an application, say that I'll pay in installment or something, you may accommodate. To that extent, I'll give. Yes.
Item 4.
May I please, your lords? Only in this case, the petitioner challenged the charge sheet as it is incomplete, my lord.
Infectious.
Incomplete, my lord.
Okay.
After the incident, the petitioner sustained
What are you
injury and
telling?
thereafter he moved to refer to Capital Hospital, Bhubaneswar, and thereafter he was admitted for 16 days. And these have and his operation operated his leg, my lord. These
You
has
are asking for quashing of charge sheet.
charge sheet from one filing of fresh charge sheet. As the charge sheet is incomplete, my lord. After they have stated that petitioner was shifted to Bhavapur, my lord, but actually from Bhavapur was shifted to Bhubaneswar, my lord. These aspect has not been found place in charge sheet, my lord. He was admitted in Bhubaneswar.
Therefore, it has to be quashed.
Unless it is quashed and then or your lordship may direct for filing of fresh charge sheet.
That's their problem. Why should I direct fresh charge sheet? That's their problem. You get advantage if wrong charge sheet is filed against you.
I am the informant, my lord. I have been.
I can't help it.
I have been sustained. I have been sustained.
I can't regulate the investigation part of it. If they have given the wrong charge sheet, then whatever consequences are there, is there?
Then the accused will be acquitted, my lord.
Correct the charge sheet. Can I correct the charge sheet?
Yes, my lord. Then matter will be taken up. There is this.
I can't. You have to move appropriate application under section 173(8) through PP or something of that sort you should do. You can't come here. You have not resorted to the right remedy.
The matter will be taken on next week. Next
week, law will not change.
Yes, ma'am. There is judgment. Then there is judgment of the apex court, my lord. Where there is incomplete charge sheet, the court can direct for.
Incomplete charge sheet, you have to go somewhere else, sir. Not 482 petition. You should right remedy. Why are you inviting problem for yourself? If on merit I'll dismiss it, then you will be in trouble. I just withdraw it, resort to the right remedy under law.
All right.
All right. Learned counsel for the petitioner seeks to withdraw this petition to avail appropriate remedy under law. With this liberty, the petitioner is disposed of. The other remedies are there.
Then unless your lordship clarify this regarding charge sheet.
How can I clarify the wrong in a charge sheet? You tell me in a 482 petition. Before you make submission, please understand what is the law. If there is a mistake in the charge sheet, in a 482 petition, I'll correct the charge sheet.
But there is a Supreme Court judgment.
Unnecessary, while submitting at least think over what they are saying. Yes.
Item 5.
Yes. 5. Nobody is it. Yes, sir.
206 kg ganja, my lord.
206
kg ganja.
Nobody comes also.
And a report also, my lord, call from my lord from this. What the status, my lord, that is a black queue, my lord. From special Jaipur.
What is this? Black? K. Q. Four witnesses have already been examined out of 9 shortlisted charge sheet. That was the review. It pass also would dispose of.
Item 6.
May I please, Your Lord?
Yes.
Here the appellant is, here the petitioner is in custody, my lord, since 23/6/2020, my lord. Your lordships may kindly see the order dated 6/4/2024. The Lorraine trial court was directed to take coercive actions for, because the victim
Attendance
is
of the
not.
victim.
Fact D.
Black?
Fact D. From the court of additional,
Yes.
ad hoc additional jurisdiction judge. Contract का मतलब.
Yes.
No POX Act.
What is the offense?
My lord, the offense under section 376,
Hmm.
2I,
Hmm.
and the
You are in
29
custody?
I am in custody since, my lord, 23/6/2020, my lord.
20.
My lord.
What to 16 time witnesses, the summons have gone? 376?
My lord,
I. Yes, yes. Mr.
and your lordships, that girl has come to the court, 161 and 161 was statement was recorded, because he it is stated that she is insane. For that reason, my lord, I am in custody, my lord. And after the victim's sister-in-law was present and seen the occurrence, my lord, thereafter, my lord, the affair has been lodged. Is a major girl, 25 years, my lord.
Girl, but she is insane, na? That's the problem.
Send one of the witness also seen matters.
Seen because he has seen that her 161, 164 my lord was recorded. My lord. And he has replied as she was vice rejected or not pressed by the before the
Oh, show me the evidence. Show me the evidence.
evidence, my lord. 161 statement, sir.
No, no. 164 is recorded.
164.
Show me.
Beyond the 164.
Who is PW1?
PW1 copy is not.
PW1 is PTI Malik. Informant. Mother of the victim. So read 164.
164, my lord. One interpreter there, my lord, and my lord, the looking into the or my lord, the
Interpreter good. Question answer form रही है ना interpreter good है.
Fact, my lord. Hore.
Lords.
Insane. What is the evidence to show that she was insane?
That the case, my chargesheet, my lord.
And she was stated that I was dragged, but no external injuries there, man.
See, I'll tell you one thing. On 25/7/2023, your bail application is rejected. 25/7/2023.
1 year is last month.
1 minute. Thereafter, P1, 2, 3, and all of them were examined in the October 23. And at least, if not the victim is not turning up, it's one issue. And the fact remains that PW 1, 2, 3, 4, all of them were examined after the rejection of bail application. So you go to trial court, revive your bail application, irrespective of the fact that whether she comes or not, whatever evidence has come, on that basis your bail application will be disposed of.
So prolonged, my lord, he's in custody as under trial prisoner.
That's right. That is why I am saying.
About 5 years.
That is why I am saying it's ideal that you should go to the court of first instance. Right on.
And lordships also observed that if the victim is not.
Yes, right. What are the date? 25/7/2020. The bail plea of the petitioner has been rejected. Subsequent thereto, in PW, PW 1, 2, 3, and 4, being the parents of the victim and other witnesses have been examined by the trial court. Repeated attempts have been made to secure the presence of the victim. However, the victim did not appear before the court. The report was sought by this court from the court below regarding the reason for not examining the victim. As per the report, 16 attempts were taken by the trial court to ensure the presence of the victim. However, the victim is not made available for the purpose of examination. In view of these changing circumstances, I am of the considered view that the petitioner should approach the trial court, being the court of first instance, and if the petitioner moves a fresh bail application, the same shall be considered on the basis of the material available on record, and taking into consideration all the attending circumstances.
The victim is not coming.
That I have written 16 times. With this observation, the petition is dismissed. Yes, please.
Obliged.
7.
Yes.
My lord, may it please your-
Yes.
My lord, may it please your lordship. My lord, the petitioner is in custody since 3/8/2022. That- 3/8/2022.
Yes.
There is an allegation by the informant, who happens to be the brother of the deceased lady, that she has been killed by this petitioner, who happens to be her husband.
Yes.
That is the allegation, your lordship. Now, your lordship, the fact remains that the investigation has been completed. I made a prayer on 2/9/2023 that I will produce the evidence recorded during the course of trial, your lordship. The witnesses are not turning up. That is reflected in the impugned order itself. Your lordship may kindly see, the entire case relies upon the fact which the informant says, and the investigation, the way proceeded, that the victim and this petitioner, they have got two sons. One is Sridhara Naik, aged about 17 years, he is the elder son. But so far the Mangaraj Naik, the younger son, is concerned, it is said that before Mangaraj Naik, it is said, the petitioner said to remain silent, and thereafter he assaulted the deceased. She succumbed to the injury and died. And this is what Mangaraj Naik has stated before the police. Then thereafter, discovery of evidence leading to the spot, and where the pond wherein the body has been hidden, and the used materials for that purpose were discovered. This is the story, your lordship. My lord, may kindly see the investigation which they have concluded. The list of charge-sheeted witnesses,
You file this thing.
they have got, your lordship. They have got the copies. If your lordship says, I will file, my lord, I have no objection, but they have got the charge sheet copy also.
Place it on record.
My lord,
Place it.
may I make a small prayer, my
Yes,
lord?
yes.
In the meantime, your lordship, there is one witness in presence of whom this leading to discovery has been done. He has absolutely turned hostile. And thereafter, your lordship may kindly see, in the impugned order, the learned court below has gone to the extent of calling a report from the explanation from the bench clerk as to why nothing is being done in this case. Annexure 2, page 11. It's for a period of, my lord, more than 1 year. And the most...
what is the status?
We said that there are one witness already.
Then it started moving now.
No, my lord, not this witness.
One witness, you were saying that.
Yes, your lordship, only one witness examined for a period of 2 years. And your lordship may kindly see, if on the basis of Mangaraj Naik, my son, I will remain in custody, then Mangaraj Naik should have been the first witness. They have not made Mangaraj Naik, a boy of 14 years, as a charge sheet witness at all. And if his 161, 164 statements implicate me, then he is required to be the prosecution witness number 1.
He is examined in 164 also.
164 also. That is very strange, my lord.
He is not cited as a witness.
Not cited as a witness. Then that will continue. But the lordship may kindly see, Anita Naik, who is the deceased, C is witness number 1. Your Lordship may imagine the way the perfunctory nature of. Your Lordship may kindly see, Anita Naik is the witness number 1 and she is the deceased. And thereafter, Mongaraj Naik is not a witness. Then he will never come to the court.
What is so callously you, it's a murder case.
Absolutely, my lord, planted. It is absolutely planted, my lord.
No, it is a complete non-application of mine. Copy
Sir.
paste somewhere they do it and file.
Mate agya kebala dhari ketra implicate karte.
Keeping the investigation open, madam.
No, investigation open doesn't mean that the deceased will be witness number 1. No, see, Anita, who is deceased, you make him, you want to examine him first.
And subsequently,
Bring her, wherever you want to. What is this? So, it's a murder case, you can't, if you have not make that boy as a witness, it's all right, it is inure to his benefit. But the fact that you are writing the deceased as a witness, it shows that the way these investigations are carried out. So casual. To place it on record, this may be a ground for place it on record.
No.
And meanwhile, you get the status, what is the, and that evidence also.
My lord. Yeah.
Already 2 years he has already undergone. 2 years, no?
Last,
22, August 22.
my lord, last occasion when the matter was listed, Honorable Court said that 2 years be completed. Thereafter, your bail will be completed.
Therefore, I'm keeping it next week or 1 week to get and get the instruction.
Safe.
I have to, see, reasoning has to be given in 302 while granting bail.
My lord,
You
said
have
that.
reasons, not that you don't have reasons. And the fact that
Your Lordship may kindly record that the original deposition copy.
Counsel for the petitioner, hands up for the photocopy of the charge sheet.
Serving a copy to the counsel.
Certificate copy of the. No, you have to file it. Certificate copy of the
Deposition.
deposition of PW
1.
PW1. He undertakes to file the document in the registry within 2 working days and leaves the matter. Meanwhile, Mr. Ragada to seek instruction regarding the present status of the trial. Please.
Your Lordship may kindly call it next week, my lord.
If he is calling, he will give you. Don't worry.
Obliged.
Yes.
May I please minute?
Yes, sir.
Minute, the status report has come in flag J minute.
Hmm.
And out of 29, 22 witnesses have already been examined, including the IO. The evidence has been closed. The argument has been closed.
Hmm.
Now it is posted for judgment in the near future. So dispose of in that right minute.
I'm recording that and
Yes,
dispose
yes.
it. Right. Where is that report?
That flag Z minute.
Z.
Z.
A report was sought from the trial court regarding the status of the trial. The learned ADJ cum special judge under POCSO Act Burger by its report dated 11/3/2024 had intimated this court that the prosecution has concluded its evidence. And
The argument has also been closed. Argument has also been closed.
And the parties have argued to the matter, and the matter is set for final disposal. In view of the said development, Mr. Rautrai submits that the matter may be disposed of. Accordingly, the petition is disposed of. In view of the development unfolded.
Yes.
Item 9.
They prefer short pass over, Mr. Pandey is just one.
Pass over.
Item 10.
Lord, I withdraw my case because case was disposed of. Withdraw my case.
Yes.
My lord, I withdraw my case because the case was disposed of.
You want to withdraw?
Withdraw.
Give the memo, sir.
Yes, sir.
Learned counsel for the petitioner seeks to withdraw the present bail application. Application. Yes.
Item 11.
No, it's the allegation is road blockage. Police came and removed the blockage, and there are some posters pasted in the trees, alleged to have been done by the Maoists. This is the allegation 2012. No overtime. Now he is in custody for last 12 years, and for last 5 years, date has been fixed for framing of charges. As yet, no charge has been framed. That is the short and sum of my case, my lord.
Furnish a report. I have sought for a report.
Yes, status report has received as per the noting, my lord, in the
Petitioner is a Maoist, my lord, as per order of
Maoist. Who is a
rejection.
Maoist? Simply telling a Maoist doesn't mean anything.
Let's come. Status report as such.
He is in custody in some case which is going
Other
on
case,
in
madam.
Bhubaneswar.
Bhubaneswar, in special court.
Special court.
Yes.
So
And
he
in
has
this
not
case,
been
no,
paid
in,
for the purpose of
no, he has been brought on remand in this case on 18/6/2018. In this case, he was brought on remand on 18/6/2018, and
No,
charge
but-
sheet was submitted in 2013, my lord.
But the court says that since the special court is not sparing him, so therefore the
But-
charge could not be.
But that's not my fault, my lord. It's a fact.
How
in-
many cases you have?
Lord, I don't know. To my knowledge, that he is facing trial in Bhubaneswar with one case, my lord. I don't know about the other cases, my lord.
My lord, there are many cases, antecedents are reflected on the order of the rejection. Yesterday night, I have talked with the concerned IAS, my lord. Cities on the way, my lord. So allow me only.
I'll put it in the next week. See,
Yes,
I'll
ma'am.
release him on the on bail because 13 years is very long time.
Yes, my lord. I do.
You
also.
will not frame charge for any reason. He is in custody of the state.
Yes, ma'am.
So it is your responsibility. You will do the logistic problem. This happened, that happened.
No, yes, my lord.
He is not sparing. He is not sparing. All these things cut no eyes.
No, last chance, my lord. Tomorrow you lord, whatever order may be passed.
Mr. Rahul, counsel for the state, submits that he has not received the CD in the present case and seeks for, accommodation. Accommodation for 2 days.
Yes, my lord.
For 2 days, leave the matter on Friday, Monday. See, in any case, even if I give him bail, he is not going out because of any case.
And this allegation in this case is very trivial, my lord. Road blockage नारायण पटना लखीमपुर करथिले पुलिस तो हटै देले देखिले गछरे पोस्टर मरा अछि पोस्टर सीज कर दिस दी ओनली थिंग लॉर्डशिप देखुन किछि हताज ना चार्ज 5 वर्ष चार्ज के फ्रेम होबन नॉट प्रोड्यूस्ड even in video my lord video he could have been produced in video right?
Video conference, anything.
Yes, it could have produced that.
Anything.
Item 14.
14?
May I please, Lords? On behalf of Mr. Nandan, my lord.
Item 14.
Here, my lord, victim is 22 years, my lord. Victim is 22 years, my lord. There is a consensual relationship. While she conceived, this affair was lost, my lord.
Show me 164.
My lord, I have annexed, under annexure 3, my lord, running page 14, the 161 statement. Running page 14, my lord.
My lord, victim is a dump lady, my lord.
Charge sheet file under what, which provision?
My lord, 3762L.
L.
Yes, my lord.
What mental disability is that?
Deep and dumb. She was not mentally disabled. Only she can speak and listen anything. Yes, my lord. That is
164 statement is there, my lord. And yeah, my lord.
How have you recorded 164?
My lord, they on 1710.
That's right. She is deaf and dumb. Then how have you done it?
By the interpreter.
Yes.
May I read, my lord?
Yes.
ମୁଁ ଅମୁକ ଆଜି ଉକ୍ତ କୋର୍ଟରେ ଉପସ୍ଥିତ ରହି ମୋର ଏଇ ବୟାନ ଦେଉଛି ଯେ ମୁଁ ଅମୁକ ପିତା ଅମୁକ ବେଲତେଜ ଗ୍ରାମ ଓରିଙ୍ଗ ଥାନା ଅରକେଲ ମାଲକାନଗିରି ଅଟେ। ଏକ ଅଜଣା ଲୋକ ନାଳ ପାଖରେ ବସିଥିବା ମୁଁ ନାଳରୁ ଗାଧେଇ ସାରି ଫେରୁଥିଲି ସନ୍ଧ୍ୟା 6ଟା ସମୟରେ। ସେଇ ସମୟରେ ସେ ପିଲା ମଦ ବୋତଲ ଓ ଟିଫିନ ଧରି ବସିଥିଲା। ସେ ଜବରଦସ୍ତି ମୋର ହାତକୁ ଟାଣିକି ନେଲା ଏବଂ ଭଙ୍ଗା ସ୍କୁଲ ଘରକୁ ସେଠି ମତେ ଜବରଦସ୍ତି ଟିଫିନ ଖୁଆଇଦେଲା। ମୋର ହାତ ଗୋଡ଼ ବାନ୍ଧିକି ଜବରଦସ୍ତି ମୋ ସହିତ ରେପ୍ କଲା ଓ ସଙ୍ଗେ ସଙ୍ଗେ ଧାନରେ ଯେଉଁ ସାର ଦିଆଯାଏ ସେହି ସାର ସହିତ ପାଣି ପିଆଇ ଦେଇଥିଲା। ସେ ମତେ ରେପ୍ କରିକି ମୋର
over the formal witnesses, witnesses. If the witness is the victim is not examined within 6 months, hence,
may I propose 4 months?
Huh?
May I propose 4 months?
6 months, 6 months, then the petitioner can also revive his bail application. Yes. Next.
Item 15.
May I please, last? Case of 302. The petitioner is in custody since 18 to 2020. The allegation is that on the day of occurrence, while the deceased and his friend returning to the home, on the way, the petitioner was assaulted by means of wooden plank. For that reason, the deceased sustained bleeding injury and succumbed to be dead.
Item number 15.
15.
My lord, I may be pardoned, my lord. This is a matter of 302, my lord. And already our office and my learned brother.
You have not received CD?
Not CD, my lord, 1 week.
Mr. Rahul and count for the respondent states that he has not yet received the CD. It seeks 1 week adjournment. List up on the case. Next.
Item 16. Item 16 means password. Item 17.
My lord, 376.
Yes.
My lord, the petitioner is in custody since 23/10/2022. 23/10/2022. Until that, no charge has been framed.
23, huh?
22, my lord.
22.
31st/10/22. 31st/10/22.
10/22.
My
yes.
And till that, no charge has been framed. And 164 statement reveals, my lord, they went to Kerala and stayed 4 months there. Thereafter returned to village.
Yes.
But in earlier BLPL number, my lord, on
Yes, my lord, that
27/7/2023, my lord, your lordship has directed to liberty to approach this court after the examination of a victim on trial, my
No,
lord.
how have you come it?
but till date, my lord, no charge has yet been, no charge has been framed. 1 year has been elapsed.
But once I have said that, where is that order?
It is, the order passed by Honorable Justice Gauri Satpathy, my lord.
I can't, I can't, go beyond that.
My
order.
lord, it's been more than,
Maybe if one court says that after the victim is examined, the other court can't grant you bail.
but my
if the
lord,
charge is not framed.
Honorable Justice Gauri Satpathy, my lord, concerned with the order passed by the court below. Therefore, this case has been come to before your lordship.
You have withdrawn it. You have withdrawn what to do.
On the 27/6/2023,
Yeah, I know, I've seen it.
এটা examination হবা বলি কি লিবর্টি নেইଥିଲି কিন্তু ବର୍ଷେ ହେଇଗଲାଣି
What is the position? Why charge is not framed?
Your lordship may call for a report, my lord, but till date no charge has been.
regarding that, no charge has been framed in the court.
Yes.
I have to take the instruction. What is the problem?
Earlier, the petitioner had approached this court seeking grant of bail by filing BLAPL number 333 of 2023. The same was withdrawn by the petitioner with the liberty to renew the bail plea after the examination of the victim by the trial court. And counsel for the petitioner submits that even after this is July you have withdrawn.
July 2023, man.
After even after the lapse of more than a year, charges is not much less examination of the victim. Therefore, he had to file the present petition. Regarding head to the aforementioned fact, it is directed that the state shall seek instruction regarding the status of the file. Please the matter.
Or your lordship may call for a report, man.
Let them get it. Yes. 18.
May I please, your lordship? Last occasion, the Honorable Court directed to obtain the status of the case, my lord. Under section 363, 376, 3, 366, 376, 2N.
Got the case diary?
Under 6 POCSO, my lord,
Yes.
CD has not come.
My lord, last 3 occasions, the Honorable Court directed.
Yes, I do admit it. Let me one chance more. 6 POCSO, 164 is
Yes, yes.
barely necessary.
Pursuant to the order dated 14/5/2024, the State Council could not could not obtain the case diary and other case diary, medical examination report, etc. And seeks 1 week time as the last opportunity. At least the matter. Yes.
And as well, status of the case, my lord.
Status of the case. Yes.
Obliged. And let my picture short date, my lord. Short date, my lord.
Give it.
May
Obliged.
plus. May plus. Petitioner is in custody since 1931/7/2023. 7/2023.
Yes.
And the charge sheet submitted under section 384, 506, 3763 of the IPC, read with section 4 of the POCSO Act. Though in the FIR, my lord, I have annexed under Annexure 1, the section under the IT Act was there, but during the course of investigation, it was deleted.
Charge sheet?
Charge sheet I have submitted
Where is the charge sheet?
with my. And the case date was called for in a 164 statement.
Where is the charge sheet? It's not there.
Charge sheet. With my lords.
Huh? Charge sheet is not there.
It is submitted on those sections.
Hmm?
It is submitted on those sections, but
How do I know? There's nothing except
record,
FIR.
in the record of the
You
Honors.
tell me, what are the offenses?
Because committed under section 376, 384, 506 and 4 posted. 66 ITF was deleted because neither the informant nor the accused, they have produced any mobile in which that
Video clippings.
You don't know what I photo.
my God, in 164 stated, those 373 is there. So this was issued to the informant and he was already appearance. And in the 164 statement, my God, she has not stated anything about the
About the.
only by the 3 lines I am reading. ଗୋଟେ ପିଲା ଦିନୁ ଲିପୁ ସାହୁ ମୋର ତ ମହାବିଦ୍ୟାଳୟରେ ଯିବା ଆସିବା ସମୟରେ ବହୁତ ହଇରାଣ କରେ ଏବଂ ମୋ ଠାରୁ ପଇସା ପଇସା ମଧ୍ୟ ମାଗେ ତାପରେ ମୁଁ ଥାନାରେ କେସ୍ କରିଥିଲି this is only 160
Nothing is. Nothing else.
In the meantime, my lord, as on 12/1/2024, when the rejection order was 12/1/2024, 3 witnesses were examined.
3 witnesses,
Yes, ma'am.
including the
including
victim.
including the victim.
What he says in the witness?
See, my lord, I'm sorry.
Tell me what.
See, my lord, stated is stated against the petitioner. In the
164 she says.
not stated, and more particularly, my lord, in the medical, she also denied for medical examination. In 164 completely rejected, and in my lord, so far the cross examination kind of a glance page are 5 and 6, my lord, for a minute.
What do you say? What do you say? In 164 you say something. In the court you say something. 161 you say something. What do you say?
161 and in deposition, same thing.
Same. Why
But in 164, she has not stated.
164 times he might have influenced things.
No, but that I am submitting, my lord. Para 5, my lord, 6, my lord, kind of a glance.
Yes.
It is a fact that I have stated before the police that I took the mobile phone of the accused and deleted my edited photograph in his mobile phone. Then next paragraph, for that reason, this IT Act section was deleted. What I have stated before the magistrate, that as per my own will, after recording of my statement by the magistrate, I also read the same and appended my signature. What the magistrate recorded in exhibit. That was recorded by the law and magistrate. It was read over and explained to her. She also, after understanding, signed it.
What do you say?
In this case, most of the witnesses have been examined. In this case, there is every chances of absconding and terrorizing the petitioner. There is a danger of the life of the petitioners.
In the charge sheet, how many witnesses are there?
In the charge sheet, there is 17.
How many of them are examined?
17 men.
How many of them are examined?
My lord, the 5 to 6 judge my.
All must be all formal witnesses. All
No,
remaining must be
since
formal witnesses.
No,
Except the IO.
only 5 to 6 witnesses have been examined. My humble submission, this is the case of the prosecution. Victim has already been examined. There is no chance of tampering with the prosecution evidences. And I am in custody since 31/7/2023. I may be enlarged or bail on any terms and conditions that I will appear before the law and trial court every day. If they are appearance, they are danger to their life, I will appear before, every week I will appear before the local police station. I am a local man. And
POXO is also there.
POXO is there because she was
16 below 16.
What is your age?
My age is
At the time of the
15.
My date of birth is 15/4/2007.
25. 25 years, madam. Having no criminal antecedent.
What do you say?
Date of birth of the victim is
See,
15.
but no, but the in 164 she says something.
164, she has not stated anything.
But in the cross examination, she said I read it and sign it.
And madam, in the examination chief, she also stated that and she narrated all the incident.
That's right. That's the fact. In that situation, I think he's entitled for bail, if not anything else. Whether he's convicted or not, that's a different story.
But in 161 and deposition copy, she has categorically stated all this.
You seek instruction.
And but one
how much time will you take to conclude the trial?
If
Next week.
there was
out of 17 charge sheet
witnesses,
about 5 witnesses have already been examined.
My humble submission.
Mr. Divedi, learned counsel for the petitioner submits that the victim, the prosecutor has not made a whisper against him in the statement recorded under section 164 CRPC. However, when she entered the witness box in the court, she has repeated her version as has been recorded by the police under section 161 CRPC. In the cross-examination, however, in the cross-examination, on the categorical question put by the defense regarding the veracity of the statement she made under section 164 CRPC, she has categorically stated that she stand by the said statement, and she signed it after reading the same. In view of the contradictions in the statement of the prosecutor is recorded in 164, and the statement she made in the as a witness of PW2, at least the petitioner is entitled to entitled to bail.
PW4 man.
PW4 entitled to bail. Counsel for the state shall seek instruction regarding the timeline for conclusion of the trial. In some case, at least the matter.
I will appear, my lord, every day.
After 1 week, let us see how much time. I have recorded everything. Made the platform for you. Yes. Item 20. Yes. Yes, 20. Yes.
20, my lord, also 3762N, 6 post-wise there.
The CD came.
CD available.
Non-APS list. Non-APS short video. Yes. 21.
376 and 6 POXO, my lord.
21, huh? 21.
My lord.
Yes.
76 and 6 POXO.
Custody since
21, my lord, this is NDPS case.
21, somebody else is appearing.
Sorry, my lord. 20.
Mr. 20.
20.
I adjourn.
Sorry.
Yes, 20. Yes. Wait, Mr. Patnaik. I am taking up 20. Thereafter, your matter. Yes.
My lord. From 164 statement, victim reveals, my lord, they married to each other and stayed
Yes.
together.
Show me 160.
This is the 160. Victim ଆଉ ତା ବାପା ମା ସାଙ୍ଗରେ ଝଗଡା କଲା ବୋଲିକି
Why are you
lodge
keeping
referred.
everything in your pocket? Why don't you file it?
Subsequently, I received.
But you got it long back, you should file. What does he say?
It is already with my learned friend, the CD, my lord.
You said everything.
Subsequently, ତା ବାପା ମା ସାଙ୍ଗରେ ଝଗଡା କଲା ବୋଲିକି I lodged the FIR
But
ବୋଲି.
he says that metric ପରୀକ୍ଷା ଦେବା ପାଇଁ ମୁଁ ତା ସହିତ ଯାଇଥିଲି, ମତେ ତା ଘରକୁ ନେଲା, ଜବରଦସ୍ତି ମୋ ସହିତ
ସେମାନେ ବିବାହ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ହେଇକି ରହିଲୁ ବୋଲିକି
ତାପରେ ମୋ ସାଙ୍ଗରେ ଝଗଡା କଲା, ମୋ ବାପା ମା ଝଗଡା
ଯୌତୁକ ଡିମାଣ୍ଡ କଲା.
That's right.
376
matriculation girl.
17 years, my lord. She claimed 17 years, my lord. More than 16.
What else?
Date of
Medical
birth.
evidence?
Medical.
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 Date of birth is 15/8/2007, man.
Yes.
So 16 years, some odd month.
Hmm.
And in the medical
Above 70.
exemption, my lord, there is nothing, no sign and symptom of recent sexuality. No sign and symptom, my lord, in a medical evidence.
No, where is that? What does it say? Medical?
And in medical, there is no sign and symptom of recent sexual intercourse during the examination. And she
Yes.
is also not pregnant.
You are in custody since?
It's been 1 year, exact date.
You tell me the date, shall I search it?
The charge sheet removed it.
No, you must know it, your application. Place it on record. Place it on record. You must know at least when you are in custody. You are asking for regular bail, you don't know when
Our
you are
custody is
custody.
3/80/23. Let the victim be examined.
Place the medical report on record.
Right.
Place the medical report. Yes, please afterwards. Yeah, next.
21. May it please your lordship?
Yes.
My lord, this is offense under 20B2C of NDPS Act
Yes.
of 153,800 grams of contaminated ganja transported. My lord, custody since 24th June 2021. 24th June 2021.
21.
My lord.
What is the stage of the trial?
My lord, charge sheet has been submitted and one number of witnesses has been examined, but which not supported to prosecution.
Not?
Supported to the prosecution witness, my lord.
Not supported.
Let him
Oh,
file
he-
that deposition copy, my lord.
Huh?
Let him file the deposition copies.
But he is from
Bihar.
Bihar. Once granted bail, then everything will be.
My lord, I have no any anticipation.
Who persons were there?
2021.
My lord, 21.
How many days you will keep in custody?
3 year, 4th year is going on, my lord.
4th year.
My lord. 3 year, 2 months.
And 100 kilo, 100 kilo.
153 kg.
53 kg.
My lord, may I play one thing, my lord? My lord, one report may be called for from the court below. That what is the status of that trial?
No, no, I will
He
not
will-
inquire. The fact remains that he is there in the custody for 4 years. You could not conclude. Let it be wherever. You tell me how to, what are the conditions you want. Merely because he is the outsider, he is a citizen. He is entitled for bail.
That is correct.
You formulate in what way you can secure what should be the condition for outsider. You think over and tell me. I'll impose those conditions and grant them bail. But merely because they're outsiders,
they cannot be
and
given custody for
you
it.
can't discriminate them. And secondly, 4 years somebody is in the custody. One should get bail within 1.5 years if you can't conclude the trial.
But every report is what an NDPS case, particularly in that area.
If
I have
the
no any
quantity is very, very huge, 500, 600 kilo or something, 100 kilo. And normally before charge sheet is filed, 50, 60 kilo, we generally give the bail.
Yes, yes.
It is 100 only.
No, 150, my lord, or 53.
All right.
And one
4 years.
condition is, my lord, that local surety.
If those things you coined,
My lord.
in what way you can secure, what best condition we can impose, anything of that sort. You think over and tell me so that I can pass the job.
And another is, my lord, that live location of that mobile number.
Live location now, Supreme Court says you can't do it.
My lord, this condition.
That's the problem. And now Supreme Court says that the privacy, you can't intrude to the privacy of merely because he's an accused. You can't keep on tracking where he's going.
My lord, this
So
condition.
mobile tracking, that condition can't be.
My lord, this condition I heard from your lordship because your lordship.
That's
moved
right,
outside
but
the
now
court.
recently, last month only that order. We can't go beyond that. You think over and
Yes.
putting it next week. I'll just see, Mr. Patnaik, let us see. Status of the State Council is directed to obtain the status of the file. List the matter. After 1 week, yes. After 1 week, yes. Out to the
22. May please, Your Lordship. Offence on 376 to N and 6 of POCSO Act. I have filed the certificate copy of 164 sheriff statement. Kindly see the flag K.
Flag A.
Flag K.
Flag K is my lord 164, but CD is not available.
Lordship, kindly certificate copy.
Let us see 164. What does she say?
Kindly.
Read it out.
Flag
Mo-
K, my lord.
Loknath Bhatra.
Loknath Bhatra. They loved each other. They fled away from home and they went to Bangalore.
मैं दुई कथाबार्ता हुई घरकू पळाइबा Yes. Are we ready? What is this? 17. The consent has no meaning, but the fact remains that she has gone with him to Bangalore and they stayed together, and she said that ଏଠାରେ ରହିବା ସମୟରେ ଲୋକନାଥ ଭତ୍ରା ଆମ ଦୁଇ ଜଣଙ୍କର ଇଚ୍ଛା ଅନୁସାରେ ମୋ ସହିତ ଶାରୀରିକ ସମ୍ପର୍କ ରଖିଛି। ଆମ ଘର ଲୋକ ଥାନାରେ ଏତଲା ଦେବା କଥା ଶୁଣି ଆମେ ପଳେଇ ଆସିଲୁ।
With though she is a minor, his consent is not really.
That's right, but
my lord, with his, with her own willing, my lord, she has gone.
This boy is also 26-year-old.
Custody since 28/11/23.
In custody since
28/11/23.
28/11/23. 23. Medical, just you show me the medical. Medical, obviously, medical will.
Medical, there is no sign symptom of the recent side no sexual intercourse.
Is there?
The CD is not with me, my lord. If he has got that certificate copy.
Show me. Do you have?
Chargesheet copy.
No, medical. Let's see. Yep. It doesn't say anything. Doesn't say anything that yes, it is right. There is no sign and symptom of the recent sexual intercourse. That's there. That's there. When this was conducted, this is conducted on 7/7/23. FIR?
FIR on 7/7/23, my lord.
This place it on record. He is entitled copy. Place it on record. File it, huh? List it next week. Then counsel for the petitioner hands for the certificate copy of the charge sheet and medical evidence, medical documents, and takes time to file, place it on record within 2 days. List the matter. He is entitled. Yes.
Next.
With some condition you are saying, because
You
cannot-
place it that on record immediately.
Yes.
I'll place it. Yeah, I'll list it on next week. Huh?
Next week, any date?
I'll give it. Yes, next.
Yes.
23.
My lord, I have taken instruction from the IO
Withdraw.
that
Withdraw.
petitioner
Withdraw.
was
Withdraw.
released on bail.
Withdraw. 24.
My lord, the petitioners before your lordships. FIR is under section 457 and 380. Charge sheet has been submitted. I am in custody since 21/12/2023.
20.
21/12/2023.
What the allegation?
My lord, they have, your lordship may kindly see the impugned order. They had looted an ATM and 7 lakhs was taken away from the ATM and 6,62,800 recovered. Page 13. It further reveals from the materials attached in the case record that cash of rupees 6,62,800 under different denomination, black plus such and such, one's oxygen cylinder has been recovered.
I think you are very systematically pursuing your profession. You are well equipped. You have cutter, you have everything.
gas-
Fiber number plate.
My lord, it is there.
Paper,
I
ticket
don't
number
dispute
plate.
it. I don't.
Gas
dispute.
control,
Very systematically.
My lord, I don't dispute. But recovering that master travel offense, I am in custody since 21/12/2020.
Yes, what do you say?
My lord, they are interstate ATM offenders, my lord. Several allegations against there, also several.
How many cases are there again?
There are 4 cases. In all the 4 cases, I've been, this is the first case. I was taken on remand in 3 cases. In 3 cases, I've been granted bail. I've got the certified copy.
My lord, but
Your
I have
lordship,
instruction that is 10 number of cases, my lord. 10 numbers of cases of similar
But-
nature.
I was remanded one after another. Any case,
How many cases are
my
there?
lord, my instruction 4 cases I have been granted.
Your instruction 10 cases.
My lord, 10 cases.
Your lordship, may kindly.
My lord, this is the forwarding report, my lord. How many cases are that they are, my lord, they are the interstate
You got the
offenders,
bail.
their duties
Yes,
that-
I've got bail. I've got bail, and that condition which your lordship is saying, that outsider, that condition has also been taken into consideration by the honorable presiding, honorable judge while granting bail. That he will produce local security, cash security, appear before the concerned police station, everything has been.
There is a direction that you should appear temporarily.
Yes, yes. Your lordship may see page 3 of the order. Outsider condition was also
Let's
there.
see. All this.
But my lord, their duty is to stolen the money from the ATM, my lord.
It has been recovered, my
And
lord.
by using that fake plate number of the vehicle, my lord. Number plate, fake number
But
plate
the
number.
problem is that you have recovered and the magistrate tribal cases, how many years you will keep it? What is the stage?
My
You
lord,
will
charge
file the
sheet
charge
has been
sheet.
submitted.
You convict him and send him, because all the cases he has got the bail. The magistrate tribal cases, how many years?
By magistrate, but my lord, the public are suffering, my lord, and the
That's
bank
right.
also suffering. But it
Ideally,
is-
you are right, but you tell me what are the other conditions, except the conditions?
Your lordship
Except the
said
conditions which are there, just.
he will not involve in similar offense. He will not.
No,
take
that
part-
injunction, despite this injunction, you have been doing it.
No. These were prior to this. After this case, I have been taken in remand in other cases.
That's what I read it, then only I am saying that
Yes,
you
I
are
have been taken in.
very systematic, professional, ATM, hacker and whatever you say.
And your lordship has also put condition that
See
he
me.
appear in the concerned police station once in a fortnight for a period of 3 months.
Every week.
Every week. Your
Every week,
lordship is
because
saying
you have to prevent him every week.
every week. I have
Madam, the petitioner is accused in file note. Give me.
Yes.
Petitioner is accused in a file. Second paragraph. The allegation is the petitioner is that he para 2, base 3 para 2. Para 2. Response for the state submit that the petitioner is an heavy criminal and he has 10 cases against him. That is reflecting in the forwarding
Forwarding report.
That is reflecting forward report. per contra, Mr. Bose, legal counsel for the petitioner submit that as per instruction, he is involved in only 4 cases. 4 cases, and in all the 4 cases, this court has enlarged him on bail with the stringent conditions. Stringent conditions. And he further submits that the petitioner is accused for an offense under section 457 of 380 IPC, which are triable by the magistrate. The petitioner is in custody since the 21/12/2023. Regarding had to the period of custody and allegation made in the FIR. Allegation made in the charge sheet. I'm inclined to grant the petitioner on bail. Accordingly, he shall be released on bail with the additional condition that he conditions over with the conditions. The petitioner shall appear before the concerned police station every week on Sunday between 10 a.m. to 1 p.m. 1 p.m. For a period of 6 months. For a period of 6 months, he shall furnish security. It is made clear that violation of any condition imposed by the court below while enlarging the petitioner on bail, or the condition imposed by this court any single occasion shall entitle the petitioner for cancellation of the bail. A single day you don't appear,
Yes.
then you are gone. And the violation, the prosecution is given liberty to move to the trial court in the event of the petitioner found violating any conditions for seeking cancellation of bail. You can move to trial court itself.
ଛତିଶଗଡ଼ ତେଲେଙ୍ଗାନା ସବୁଆଡେ ତାଙ୍କର ଅଛି antecedents.
Then every week you will. And you know how to curtail them. In one case he got bail, in book another case.
And they have been doing so.
That's the
they
best way of controlling you people. Otherwise, it's very difficult to control.
From Chhattisgarh and Karnataka, that antecedent is there. It was police obtained that in antecedent from Karnataka and Chhattisgarh. They are involved in that state also.
The state council submits that the petitioners are involved in the multi-state involved in crime in different other states also. That also you record. Yes.
25 May, please.
Yes.
May, please. The petitioner has been forwarded for offences under section 302, 120B and 34 IPC. Unknown FIR, my lord. And during course of
CD already called for?
Yes, my lord.
Yes, tell me.
My lord. Unknown FIR, my lord. During
custody since?
Custody since
4/9/2023,
my lord.
Yes.
During course of investigation, it is alleged that the IO got information regarding involvement of the petitioner in the alleged crime, so apprehended him, and during course of interrogation, the petitioner admitted that he has committed the murder. That is the case.
Except
it is mentioned.
Statement,
My
what
lord,
you are.
Yes.
but the fact is that, my lord, the present petitioner has given supari to kill the deceased. He has given supari of rupees 1,60,000 to one Bineshwara Giri and Pondatiri. This that the who has taken supari, his name is Babal Birwa. That Babal Birwa, man. Birwa. Babal Birwa is still now, my lord, he was absconded.
He has committed the crime.
He and other 2 persons, Bineshwar Giri and Pondotiria. 3 persons, they have assaulted and they have killed the deceased.
And he has given the
supari.
What are the evidence?
My lord, evidence is, my lord, that the confessional statement of the own petitioner, as well as, my lord, the persons, that is the extrajudicial confession, my lord, before one person.
Page 16, Lordship, kindly.
I'm reading.
Who has made
present petitioner has made extrajudicial confession before the one person, my lord, one
saying that I have
independent witness.
paid, already paid?
My lord, I am reading that question.
Alright, so confession and extrajudicial confession.
Confession and extrajudicial confession.
So,
Confession,
extrajudicial-
extrajudicial confession my lord, before the Sushant Kumar ji, ଯେ ମୁଁ ଭୁଟୁ ସାହିର ଦାସଲାଗୁରି ପାଖରେ ମଜୁରିଆ ଭାବରେ କାମ କରେ। ଦାସଲାଗୁରି my lord is the present petitioner. ଦାସଲାଗୁଡିର ଦାସଲାଗୁଡି ବେଆଇନ ଭାବେ ଦେଶୀ ମହୁଲି ମଦ ବିକ୍ରି କରେ। ତାର ଘରେ ମୁଁ କାଠ ମହୁଲ ଆଣିବା ଅନ୍ୟ କାମ କରେ। ଭୁଟୁ ସାହିର ଦାସଲଗୁରି ଓ କିର୍ସନ ସିଂଙ୍କୁ ମହୁଲି ମଦ ବେଆଇନ ଭାବରେ ତିଆରି ବିକ୍ରି କରନ୍ତି। ଦାସଲାଗୁରିର ମଦ ମଝିରେ ମଝିରେ ଖରାପ ହୋଇଯାଏ, ବିକ୍ରି ହୁଏ ନାହିଁ, ଯାହା ଫଳରେ ଲସ୍ ହୋଇଯାଏ। ତେଣୁ ଦାସଲାଗୁରି କିର୍ସନ ସିଂ ଇଜ ଡିସିଟ୍, କିର୍ସନ ସିଂଙ୍କୁ ସନ୍ଦେହ କରନ୍ତି, ସେ ଗୁଣି କରି ମୋର ମଦକୁ ଖରାପ କରିଦେଲା। ତେଣୁ ଦାସଲାଗୁରି କିର୍ସନ ସିଂଙ୍କୁ ରାସ୍ତାରୁ ହଟାଇ ଦେବି କହି ବର୍ଷେ ତଳୁ କହିଥିଲେ ଏବଂ କିର୍ସନ ସିଂ ସହ ପାଟିତୁଣ୍ଡ ମଧ୍ୟ ହୋଇଥିଲା। ମୋତେ ଆଗରୁ ମଧ୍ୟ କହିଥିଲା ଯେ କିର୍ସନ ସିଂଙ୍କୁ ରାସ୍ତାରୁ ହଟେଇ ଦେବି, ହେଲେ ମୁଁ ମନା କରିଥିଲି, ତୁ କର ନାହିଁ, ତୋର ତ ଏବେ ଭଲ ରୋଜଗାର ହେଲାଣି, ସେମିତି କାମ କରନା। ସବୁଦିନ ପରି 20/6/23 ସମୟ ଭୋର 5ଟା ସମୟରେ ମୁଁ ଦାସଲାଗୁଡି ଘରକୁ ଯାଇଥିଲି। ସେତେବେଳେ 3 ଜଣ ଲୋକ ଗୋଟିଏ ମୋଟର ସାଇକେଲରେ ଦାସଲାଗୁଡି ଘରକୁ ଆସି ଦାସଲାଗୁଡି ସହ କଥା ହେଉଥିଲେ। ମୋତେ ଦେଖି ସେମାନେ ଚୁପ୍ ରହିଲେ ଓ କିଛି ସମୟ ପରେ ସେମାନେ କାଙ୍ଗିରା ନଦୀ ଛେଳି ଅନଳି ପାଟକୁ ଗଲେ। ସେଦିନ ସକାଳ 8ଟା ସମୟରେ ଶୁଣିଲି କି କିର୍ସନ ସିଂଙ୍କୁ ଛେଳିଆର ଜଙ୍ଗଲ ରାସ୍ତାରେ ହତ୍ୟା କରିଛନ୍ତି। ସେଦିନ ଦାସଲାଗୁଡି ମୋତେ କହିଲା ଯେ ମୋର କାମ ହୋଇଗଲା, ମୁଁ କିର୍ସନ ସିଂଙ୍କୁ ସଫା କରିଦେବି। ଏବେ ଜାଣିବାକୁ ପାଇଲି ଯେ ସେ 3 ଜଣ ଲୋକ 2 ଲକ୍ଷ ଟଙ୍କା ଦେଇ ହତ୍ୟା କରିଛନ୍ତି। That is the extrajudicial confession, and from that supari killer man against whom 3 persons they have killed, one from Bineshwar Giri 40,000 rupees was recovered, from Pandu Tiria 20,000 recovered, and Bineshwar Giri leading to discovery knife was also seized.
Out of the 3 accused, supari killer,
one is absconded
from
another two knife and 40,000 rupees and 20,000 rupees was seized.
Against materials are there.
So against me, the only allegation that I have given supari to kill the deceased, my lord. Well, Lordship may kindly peruse page 16 of the impugned order. Itself it is mentioned that during course of interrogation, the petitioner confessed that he has provided supari to 2 persons.
I'm not emphasizing on confession. Your confession is neither here nor there. Except confession, what are the materials? Materials, the extrajudicial confession, and the 2 co-accused persons, from there the money is recovered and weapon of offense.
Money is recovered, weapon is recovered, but they have committed the murder, and there is no
evidence.
That is
their case.
No evidence that I have been involved in the crime, my lord, except confession.
Is there. There are evidence. Not that involvement is there.
That is the co-accused statement, my
done
lord.
it, but you have employed people to do it.
That is the co-accused statement. The evidence is that co-accused statement. Except that, there is no other material.
How many witnesses are there? What is the stage?
The 31 numbers of witnesses are there.
There is no eyewitness. There is nothing.
There is no circumstance. There is no eyewitness. Only that extrajudicial confession.
Any condition, your lordship may.
What is recovered from the weapon?
My lord, knife 40,000.
Show me the medical. Knife injuries are there. Do you have medical paper?
My lord.
Yes.
My lord, there is wound present over chest, middle sternus, 4/3. That is to 3 numbers of my lord injuries are there. On a spinal cord, and the cause of death is homicidal is in nature due to sharp weapon of knife.
Charge sheet file.
Charge sheet
file.
When charge sheet file?
My lord, charge sheet submitted on 1/1/2024.
1/1/2024.
24. My lord.
Then you have to go to, you see, at the time of investigation, when investigation is going on,
Yes.
you approach the court, and the court says that the investigation is still going on. So
Investigation is still going on.
So therefore you go right on. The petitioner is agreed by the order dated 21/11/2023, where passed by the court of additional sessions Karanjia in BA number 187 capital 8 of 2023, whereby the bail plea of the petitioner is turned down. The trial court has rejected the bail plea on merits and on the ground that the investigation is still going on, so therefore investigation is still going on. Then Constable Chief submits that after investigation, charge sheet has also been filed on 1/1/2024. From the charge sheet, it reveals that the present petitioner, although is not involved in the commission of the crime, however, he is the mastermind behind the entire sequence of event. It is alleged against him that he has paid about 1,60,000 rupees to 3 super killers to eliminate the deceased, who was a business rival, who was his business rival, business rival. The petitioner is in custody since 4/9/2023. In view of the fact that charge sheet has already been laid down and evidence is already collected by the police regarding the factum of giving supari for killing the deceased, Krishan. What is the name? Killing Krishan Kumar. What is it?
The deceased.
This is Krishan whatever.
Kishan Sinku.
Krishan Sinku. Sinku. I am of the opinion that the
Kishan Sinku.
the trial court on the change of circumstances, changing circumstances, reduce the bail with this observation, the petitioner is disposed.
Grant liberty mail.
Liberty. Where is the application?
IA 779/24. IA 779/24.
To me, what are the illness?
The illness is that the doctor certificates are there and the doctor authorized.
Verified it.
No, madam. That case he has filed.
Notice in interim application. Appearing for? Let us verify the entire.
Trial is at starting stage. Out of
Okay, 17.
17 days.
Out of 27.
Seven witnesses are pending. Seven witnesses are ଅଛନ୍ତି ମୁଁ ଆଜ୍ଞା regular bail ମାଗୁନି ମୁଁ ଆଜ୍ଞା ଖାଲି.
That's right, but see, you have placed on record some medical record, medical prescription obtained from a private doctor.
My lord, they advise that better treatment patient refer to SC medical. That is why
Abdominal pain.
My lord. Abdominal pain. I'm seeking some. Now I am seeking, my lord, IA for interim bail. Move.
Okay, let him verify. Let us see. Verify. Issue notice and verification. Yes, next. 27. Yes.
Short date, my lord.
Let it verify after 2 weeks. Yes, next.
This one I prefer after launch matter, because in the meantime, victim as well as a parent has been examined matter. I have the copy, I have to only download my lord.
1 week after. Yes.
After launch,
1 week after.
It's with me, my lord.
Yes, it's all right. You file it. Next.
A date may fix, my lord.
Yes, next.
28.
It went out on behalf of SR Das, not well today can taken up any. On behalf of SR Das, not well today can taken up.
Urgent.
29.
See, the bail applications are not coming. Once it is listed, you are seeking time. And once you seek time, it will be urgent to September. Before that, you don't mention.
Inform me over 4 minutes.
I'm adjourning it to September if those who are seeking time. Because there is no scope of taking it before that. Yes. Next.
29.
Yes.
Lordship, the alleged offences are under section 376 2N, 506, 341, 427, 376 3 of IPC, read with 6 of POXO Act and 66 E of IT Act. Lordship.
What are the allegations against you?
Lordship, the allegation is that the petitioner is the friend of the son of the informant, and the petitioner used to visit her house while her daughter Suchismita was reading in class 9. The petitioner forced her daughter on the point of pistol to love him. As a result, she fell in love with the petitioner. In the year 2021, the petitioner captured some obscene videos and videos of the victim and started blackmailing her. The petitioner also kept physical relationship with her against her will. On date 5/4/2023, she along with her daughter returning from Ellen College, Jamsuri, their way the petitioner along with his friends arrived.
Show me your 164 statement.
That's page number 31.
31. Yes. Yes.
Lordship, there is lots of inconsistency in the FIR along with the statement recorded under section 161 statement and 164.
I'm not going to see the discrepancies or what you call contradictions. Just see the allegations. Where allegations are there, then you are in custody since?
I'm in custody since Lordship 11/10/2023.
22.
23.
23. Okay. Yes. Read out the
164. ଘଟଣା 3 ବର୍ଷ ତଳେ ଘଟିଥିଲା ଆମ ଘରକୁ ବୈଦ୍ୟନାରାୟଣ ପଣ୍ଡା ଏଲିୟସ୍ ବାପୁନ ପ୍ରାୟ 3 ବର୍ଷ ହବ ଯିବା ଆସିବା କରନ୍ତି ସେ ମୋ ସହିତ ମୋ ମାଙ୍କ ସହିତ ଭଲ କଥାବାର୍ତ୍ତା କରନ୍ତି ଦିନେ ଆମେ ଘରେ କେହି ନଥାନ୍ତି ସେ ଘରକୁ ଆସି ମତେ କହିଲେ ମୋ ମାଙ୍କ ଫୋନ ନମ୍ବର ମାଗିଲେ ମୁଁ ମୋ ମାଙ୍କ ଫୋନ ବ୍ୟବହାର କରୁଥିଲି ମୁଁ ତାଙ୍କୁ ପଚାରିଲି କଣ ପାଇଁ ନମ୍ବର ମାଗୁଛ ସେ କହିଲେ ସେ ମତେ ଭଲ ପାଏ ମୁଁ ଯଦି ନମ୍ବର ନ ଦେବି ସେ କହିଲା ଯେ ସିଏ ମୋର ଭାଇକୁ ମାରିଦବ ମୁଁ ବାଧ୍ୟ ହୋଇ ମାଙ୍କ ନମ୍ବର ଦେଲି ମୋ ସହିତ କିଛି ଦିନ କଥା ହେବା ପରେ ମତେ କହିଲେ ଯେ ମୁଁ ବାଥରୁମ ଯାଇ ତାଙ୍କୁ ମୋ ନେକେଡ ଭିଡିଓ ପଠାଇବି ମୁଁ ତାଙ୍କୁ ମୋ ନେକେଡ ଭିଡିଓ ହ୍ୱାଟ୍ସଆପ ରେ ପଠାଇଲି ସେ ମତେ ବୁଲିବାକୁ ମଧ୍ୟ ଡାକିଥିଲେ ସେତେବେଳେ ସେ ମତେ ସେତେବେଳେ 10ମ ଶ୍ରେଣୀରେ ପଢୁଥିଲି ଓ କରୋନା ପାଇଁ ପରୀକ୍ଷା ବନ୍ଦ ହୋଇଗଲା ମୁଁ ତାଙ୍କ ସହିତ ଦୀଘା ବୁଲିବା ପାଇଁ ଯାଇଥିଲି ସେଠାରେ ସେ ହୋଟେଲ ବୁକ୍ କରି ମୋ ସହିତ ଜୋର ଜବରଦସ୍ତି
said there is a love affair between the accused and the victim, Your Lordship. However, only because the victim is of less than 18 years of age, I am inside custody, Your Lordship.
The boy of
I am a major person, Your Lordship. I am a major person. And
what is the stage of the trial?
Your Lordship, as far as my instruction goes, trial has not come in subject to verification, Your Lordship. I am only pressing my case because this seems to be a consensual case. And Your Lordship.
No, consensual is all right, but the problem is POXO is there.
Yes, Your
164, where is 164?
Your Lordship, the count.
You have 164 with you. Just read it out. Let us see. Use the mic. Use the mic. Yes.
ଦାଣ୍ଡ ଯାତ୍ରା ଦେଖା ହୋଇଥିଲି ସେ ମୋତେ ତାଙ୍କର ନମ୍ବର ଦେଇଥିଲେ ତା ପରଠାରୁ 2 ରୁ 3 ଦିନ ପରେ ତାଙ୍କୁ କଲ୍ କରିଥିଲେ ତାଙ୍କୁ ତାଙ୍କର ଟାଇଟଲ ପଚାରିବାରୁ ସେ ମୋତେ ତାଙ୍କ ଟାଇଟଲ ବେହେରା ବୋଲି କହିଥିଲା ସେ ବେହେରା ବୋଲି ମୁଁ କଥା ହେଲି ସେ ମୋତେ ପଚାରିଲା ତମେ ରାଜି ହେବ କି ବାହା ହେବା ପାଇଁ ମୁଁ ମନା କରିଥିଲି ସେ ମୋତେ ଦିନେ କହିଲା ପଳାଇବା ନହେଲେ ତୋର ଫଟୋ ଭାଇରାଲ କରିଦେବି ମୁଁ ତାପରେ ଡରିକି ଗଲି ସେ ତାପରେ ମୋତେ ବାହା ହେଲା ଏବଂ ତାର ଆମେ ଘର ଭଡ଼ା ନେଇ ରହିଲୁ ସେ ତାର ଘରେ ମୋ ସହ ଜବରଦସ୍ତ ଶାରୀରିକ ସମ୍ପର୍କ ରଖିଲା ତାପରେ ଆମକୁ ପୋଲିସ ଧରିକି ଆଣିଲା ଏବେ ମୁଁ ଜାଣିଲି ଯେ ବାହା ହୋଇଛି ଏବଂ ତାର ଗୋଟେ ଛୁଆ ଅଛି medical examination
staying together, so that is
that
not
is my
illegal.
no bodily injuries on or suggesting forcible sexual intercourse, no sign and symptom of recent sexual intercourse, victim has changed her clothes, victim is not pregnant at the time of examination and original medical examination.
Charge has been framed.
But that instruction is not there, Marat. I have talked to him.
Counsel for the state to obtain the exact status of the trial, huh? Right, least after 1 day. Let us see if the victim is to be examined first.
Your Lordship, that is what my contention is with the repeated observations of the Honorable Courts, Your Lordship. She has stated, and apparently
The problem is,
Yes, Your Lordship.
once he is released on bail, he may influence the witness.
Yes, madam.
No, Your
That's the
Lordship, Your
problem.
Lordship, that will only arise if it is a case of consensual relationship.
That is.
That I agree. But Your Lordship, the courts have also observed that if consent is arising from the fact and consent is law is not taken into consideration. But however, I'm being placed into prosecution. Here she has clearly stated that she is the one who has approached me. Your
That's
Lordship.
right, you are
Yes,
absolutely
Your
correct.
Lordship.
I am not on
And
that.
by that time, the victim is also of 17 years. So between a girl of 17 years and a boy of 24 years, 25 years, Your Lordship, that is factually.
What I'm trying to ascertain is if the witness could be examined shortly,
Yes,
then
Your
we can
Lordship.
very well wait
Yes,
for
yes.
that.
Charges
If there
submitted.
is no chance of the victim to be examined for a longer time, then on the basis of the material available,
Your
I
Lordship,
will enlarge on bail.
my only prayer is that Your Lordship has the discretion to enlarge
Yes,
me
of
on
course.
bail before charge
Of
also,
course,
Your
because
Lordship.
I just see the age of the boy.
Yes,
The
Your
age of the boy and the girl is not much difference.
Yes,
They are
Your
young
Lordship.
people.
Yes, Your Lordship.
And there is a consensual this thing.
Yes,
Merely technically, he has done the
Yes, Your
crime.
Lordship.
That has to be seen.
That has
And
to-
you would ask, at the same time, you would ensure one thing, that the trial should be also fair enough.
Yes.
Because
Yes,
see, this girl
indeed, Your
is
Lordship.
naturally under the influence of the boy.
Your Lordship, then
Once he comes out, the right
Your Lordship, while
thing
giving
may not come on record.
Your Lordship,
That's the whole idea.
while stating her 164 statement, she was not under my influence. Rather, she was under the influence of her parents. Still, with her parents also, she has given this type of statements. Despite giving this type of statement in
But you have
164,
seen
do
the
you?
earlier one matter, 164,
Yes,
she has said
Your Lordship,
nothing.
that is a.
And when he went to the court, she said everything.
Everything.
So that is also another situation. Wait, let us see next week.
Yes, Your
Huh?
Lordship. Much obliged.
You are entitled to bail. I am not saying that
Much
you are not
obliged.
entitled.
Much obliged.
31.
The petitioner is in custody since 7/4/23.
7/4?
23.
Hmm.
Offense is 341, 294, 323, 325,
Yes, allegation.
326A, 307.
Allegation.
Allegation, my lord, throw acid on 4 persons. There was dispute between two family.
Where is the FIR? You have not filed anything in the name of this thing. Except the rejection order, you have not placed anything on record. At least I am entitled to know what are the allegations against you in the FIR. Where is the FIR? You have not filed anything except the rejection order. You filed? Except the impugn order whereby the trial court has rejected the bail plea of the petitioner. Nothing is placed on record by the petitioner. He seeks 1 week time to place on record the relevant document to substantiate his case of substantiate his plea of bail. Release the matter up to 1 week. File it also. At least FIR, whatever charge sheet, nothing is filed. Yes. File it. I'll take it up. Yes.
Short date, my.
Yes. Next.
32.
Yes.
Yes, ma'am. This is the case was registered under section 376 2N.
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 Yes.
The victim jar is Major Jal at time of the occurrence. And as per the investigation, police submitted charge sheet, complete the investigation, and the investigation revealed that during course of investigation, it is assertion that the Om Prakash Bari, the present petitioner, working as a helper in rations of Vikas Patra at Gambira Munda, many often time victim Bobina Pradhan had been go to his shop, this shop for purchasing grocery articles. In this process, they are known to each other and both are fell in love. And subsequent, fell in love. On dated 22/12/2023, the accused had given false assurance to victim to a new job at Bhubaneswar. He had taken him from village Raknathpur, but instead of Bhubaneswar, accused Om Prakash took her in Puri. Both are stayed in a labor room, temporary room under construction building, private hospital, Goli Chatra, Baliapoda, or district Puri, in 6 days. During the 6 days, the above noted accused forcibly sexual intercourse several times with the victim without her consent. That is the allegation.
And
164?
164 is record. I have no 164, but 161 is there.
164 do you have?
164 is there, madam.
What's give you? What is the age of this prosecutrix?
At time of occurrence, 8 years, 3 months, madam. As per the investigation result. At the
Yes.
date of birth is
164.
yes, madam.
Yes.
That Bebina Pradhan, madam.
Custody
Trustees 28/12/2023, madam.
28
12
12
2003, madam.
2023.
Yes, madam.
Yes. Yes, read it.
My lord. ओम प्रकाश को भल पाउथली गत खोर्धा जाइछि बोली कहि मु ओम प्रकाश सहित बस रे भुवनेश्वर गलु सेठू आमे दुहे पुरी जाइथिलु पुरी रे ओम प्रकाश रो जणे नाना जणे काम करंती ओ तांको घरे रहिलु आमे किछि दिन गोटे रूम रे रहिलु ओम प्रकाश मते बा हेबे बोली कहि शारीरिक संपर्क रखिया को कहिला आमे दुहे गोटे रूम रे सोइलु से मो सहित शारीरिक संपर्क रखिला से मते कहिला चाल गाँ को जीवा सेठी बाहा बा गतकाली सकाळ आमे पुरी
He is entitled for bail.
My lord.
Entitled for right of.
With condition, my lord.
Huh?
With
No,
some
whatever condition you want.
My lord, you will appear before the trial court on its date of posting.
Oh, that is always there.
Appear before the local
Any
police.
other, what is the antecedent?
Local security. Antecedent part is, my lord.
He is outside or what?
No, my lord. That nothing adverse, my lord, against him.
Then
as per the instruction.
Okay, consensual check. Right. Petitioner is accused also. That constitutes a petition. After investigation, charge sheet has been filed on filed on 23/2/2024. The petitioner is in custody since 2012-2024. The now from the charge sheet it reveals that the petitioner was in love relationship with the prosecutor. On the promise of marrying her, he took the petitioner, he took the prosecutor to Puri and they stayed together. During their stay, they had sexual encounter. Since the petitioner has falsely assured the prosecutor to marry and subsequently resigned from his statement, the FIR has been filed. The fact revealed the investigation from the investigation investigation reveals that although the sexual encounter has taken place on the consent, but for the fact that the petitioner has resigned from his promise to marry, the present FIR has been filed. Taking into consideration the period of custody, nature of allegations, also the petitioner is entitled to bail and entitled to bail and the petitioner shall appear before the court on his date of hearing, and he shall not keep in communication with the victim till her examination in the till she is examined by the till his deposition is over, and he shall not influence any witnesses any violation of any condition will entail this application. Please. Yes, next.
33. May I please?
Yes.
My lord, the petitioner has been inside custody.
Yes.
Since 11/10/23, my lord.
11/10?
11/10/23, my lord.
Yes.
On the basis of FIR which had been lodged on 9/10/23, the alleged occurrence took place on 5/10/23.
Yes.
It is alleged that one side is there of a grander, which is a gay side. In that gay side, the informant telephoned and have a friendship with one Sunil. And thereafter, he contacted him for a physical relationship. And then the Sunil picked the informant and took him to the garage shop, and where the petitioner has a relationship with the informant. Subsequently, 3 persons came there and they abused him and blackmailed him that we have the pictures and we will blackmail and you transfer to the PhonePe account of ₹56,000 to the account of Krishna Pradhan. And accordingly, the informant transferred the amount of 56,000 36,000 to the account of Krishna Pradhan in the phone pay. It is not at all a case of 395.
What is your role?
My role have a relationship with that person. After
Which person?
the informant, the gay, as in the he has contacted to Sunil, have a for a gay relationship. A person with another
The
boy.
informant called one Sunil.
One Sunil.
For having a relationship.
Relationship.
Gay relationship.
Gay relationship.
You are the friend of that
Sunil. Sunil.
And
The
then
Sunil took him to the garage shop, where I am there, and I took him, and I have a relationship with him. At that time, those 3% took the pictures, and they blackmailed him and took 56,000 through phone pay to Krishna Pradhan. Those Krishna
you
Pradhan
also involved in this.
that is the total background of the
Then
case.
you are supposed to be the victim.
Yes,
Your photograph is taken.
my photograph has been taken. The 4 persons who are there, they are the juveniles, for which on the same day they have been forwarded and released on bail. As I am a 19 years old man, for which I am inside custody.
Yes.
And in another case, 282, PS, another same allegation has been made, and thereafter this affair has been filed. That PS case number 281, I have been granted bail by this honorable court.
What is the allegation there?
Same allegation. Another victim. PI pair identified all the 4 persons, and money
You are
has,
doing the same thing with that person also.
and in that case also the same allegation.
Allegation, but the different person.
Different person.
Yes.
After 5 days, affair has been lost. After getting information,
Show me
that is the.
Yes, sir.
My lord, in this case, my lord, as per the rejection order, charge has already been framed, my lord.
That's not allegation.
I have been granted bail in that case, my lord. Same allegation.
Having one antecedent also.
That case. 281, thereafter this is the
281,
reminder
everything
case.
Under 394, similar nature, my lord.
Similar case. Other co-accused persons have been granted on the same day, my lord, as they are the juvenile. All the 4 persons.
In how many cases you are involved?
2 cases. 281 and 282.
So far, 2 cases.
No other case.
After release on bail.
No case, my lord. I am a young boy.
You have a very good methodology of extracting money.
Now the other 4 persons who have the
You
contacted.
take the persons by making them to drink something, and thereafter you take to a room.
That is
with
not
other
allegation
people.
against me, my
You
lord.
have sexual relationship with
That allegation
man,
against that Sunil.
Take a photograph and then ask for money.
That the Sunil and the other person, that
And
the
you
allegation.
are one of the accomplices.
Yes, my lord.
That is
Other
what
4
it is.
persons, they have released on bail, my lord, as they are the juvenile, my lord.
Show me the allegation. Yes, sir. What condition you want?
He will
security-
appear, my lord.
Local security, and he will appear before the trial court on his date of posting, and
That
he shall appear
is
before
there,
the-
my lord. The condition is there, he will appear in the trial court on each statement.
The petition is accused and so on. The allegation against the petitioner is your allegation. Where have you written the allegation? Okay. The charge sheet has already been filed in this case after investigation. After investigation is complete. The petitioner is also involved in another case, being Lingaraj PS case number 281 of 2023, corresponding to city case number 776 of 2023. The allegation in that FIR and the allegation in the present FIR is where what I'm saying. In the FIR, number 281 of 2023, the petitioner applied for bail before this court. By filing ABPL number 14073 of 2022. This court, by order dated 2/5/2024, allowed the the allegation relevant would be to reproduce para 4 of the shade order, shade order to appreciate the relevancy of the allegation made in that affair. If we taking into consideration regarding to the fact that the petitioner is in custody since 11/10/2023, and the trial is likely to take considerable time, I'm inclined to grant the petitioner on bail, domestic, and this is condition that the petitioners are not involved in any other similar case, and petitioners shall appeal for the IIC. Which IIC?
Lingaraj PS.
Lingaraj PS every Sunday, every Sunday for between 10 AM to 1 PM for 3 months. 90 months. Yes. You appear for 3 months so that you will not commit at least similar. 34. Yes.
May I please, Your Lords? My Lord, the petitioner is in custody since 15/7/23. Charge sheet submitted in this case, my Lord. Allegation is that the present petitioner, while the victim was informant is the daughter-in-law of the victim, while the victim was returning home, the present petitioner forcibly took him by the side of the road and committed the offense.
376.
My Lord.
Fox also.
No, my Lord. The age of the victim is 65 years, and the petitioner is more than 50 years. My Lord, the investigation shows the police said that the
164. You have?
Yes,
What is the list? You are in custody since?
My Lord,
15/3 to
15/7/23. 15/7/2023.
15/7/23. Okay. What is the allegation? Let us see. 164, read to 164.
My Lord, ଗତ ଶୁକ୍ରବାର 14/7/23 ସନ୍ଧ୍ୟା 5ଟା ବେଳେ ଧାନ ପଲ୍ଲା ଜଗିବା ପାଇଁ ମୁଁ ସ୍କୁଲ ପଡ଼ା ଆଡ଼କୁ ଯାଉଥିଲି। ମୁଁ ସ୍କୁଲ ପଡ଼ାକୁ ଘରକୁ ଫେରିବା ସମୟରେ ଆମ ଗାଁର କଟୁ ଟୁଡୁ ମୋତେ ଉଠାଇ କରି କଲୋନୀ ପଡ଼ା ଆଡ଼େ ନେଇଗଲେ। ସେଠାରେ ଜବରଦସ୍ତି ପଳସା ଗଛର ତଳେ କାମ କଲେ। ସେ ଜବରଦସ୍ତି ମୋର ଶାଢ଼ୀ ବେଇଜ୍ଜତ କଲେ। ତାପରେ ସେ ମୋତେ ସେଠାରେ ଛାଡ଼ି ଦେଇ ପଳାଇ ଗଲେ।
Bas. Medical?
Chemical examination. Man, the chemical. I am submitting the chemical examination.
Number 7, my Lord.
Sample 7. Genital injury observed suggestive of sexual intercourse. However, final opinion needs the result. Pending in the availability of FSL report. FSL report from
my Lord.
There are genital injuries.
My Lord. Yes, my Lord. And the chemical examination report shows that there is no
opinion can be given as to whether the alleged accused in the case under the reference how many recent sexual intercourse in the ordinary way, and there is nothing to suspect about his potency. Yes, sir.
Well,
if you read, see, the doctor says that genital injury observed suggestive of sexual intercourse. However, the final opinion is reserved to pending the availability of FSL report. But FSL report says no definitive opinion can be given as to whether the accused in the case under reference had performed recent sexual intercourse.
we can understand.
Right. I'll write it. On 14/7/2023 at about 9:45 PM, one Sunita Bura, wherein mentioned as the informant Sunita Bura presented a written report in the PS alleging that on the same day at about 5 PM, when her mother-in-law had been to the village for some work, the petitioner tracked her mother-in-law towards the roadside bushes, and which one Jiten Bora was a witness to the occurrence. When her mother-in-law protested, the petitioner forcibly took her inside the junta and committed rape on her. When the above Jiten Bora went near them and shouted, the petitioner left and fled away from the spot. On the same day, medical examination of the victim was conducted, and the doctor opined that the inverted comma before genital injuries observed suggestive of sexual intercourse. However, final opinion is reserved to pending availability of FSL report. FSL report. The FSL report, has been filed along with the charge sheet dated 25/8/2023. It reveals as under para 5. Para 5. So therefore, para 5. Taking into consideration the medical report as well as the FSL report, inference could be drawn that inference could be drawn that there was no recent sexual intercourse that is taking place. Taking into consideration the period of custody, I mean, the petitioner is in custody since 15/7/2020. Taking into consideration the period of custody and the nature of allegation, also granted bail with the same condition. He will not be in contact with condition, same condition. You will not be in contact in any manner whatsoever with the victim till her deposition is made. Okay. Okay. Next. 35. Yes.
My lord, petitioner being implicated in a case under section 302/201
Yes.
is in custody since 10/10/2023. Charge sheet has already been filed. Petitioner is the mother, and allegation is that she had killed her baby of 5 days.
TD has come.
Yes, my lord. Committed murder to
Mentally,
her own child, my lord.
mentally disordered woman. That is there during investigation. It has come out.
Postmortem report is there, my lord, and other statements.
Where is that mental disorder?
That is there in the investigation.
Show me. This lady is mentally disordered.
Yes.
My lord.
Mentally. Show me. She is 20 years, huh?
Yes. One child is there. One son is there.
You should remain in the custody. You will get treated also. I'll pass that order. See, the problem is she is mentally disordered. She comes and she may create some problem. You need medical attention, which your husband, I don't think, can give. The state can give. Merely bringing her out will not serve any purpose. He needs treatment. What are the what do you call the medical report?
Medical,
insofar as this lady
my
is
lord.
concerned?
Medical report, my lord, that pressure abrasion present around neck with almost.
No. About this lady, the accused.
Petitioner, my lord.
Yes.
That only, my lord.
This is only the opinion of a police, or have you
No,
got some medical?
That is there in case diary, my lord. Just now I received the CD, my lord. That is
You ascertain and tell me. Next.
Yes, my lord. My lord.
But if wherever there is a CD, you prepare and come, because there are a lot of matter. I can't.
Yes, my lord.
You can't read it here and tell me. You just read it, prepare and come. Next
lord.
week. Next time. 36.
Next week, my lord.
Withdraw. Yes. Next week. Yes.
My lord.
37. Yes.
May I please your lordship?
Yes.
May I be permitted to withdraw, my lord?
Yes. Withdraw.
Obliged.
38.
Pardon, Lordship, on behalf of A. Patra, this matter should be taken up to 2 weeks after seeking adjournment.
Adjournment request September. Yes. 39.
I beg to submit, my lord. The petitioner is in custody since 13/10/2023, my lord.
13/10?
2023.
Yes.
The offence is and alleged offence is under section 376(1).
Sorry?
300? 376(1).
376, okay.
I received. And the victim is aged about 26 years, my lord.
Show me the, you have?
Yes, sir.
Her 164 statement, read.
Yes, sir. I am ready.
She was, she is now 26 years. No POXO.
And it's approved.
Read it out.
Page 12.
Yes.
I am reading. I'm reading.
Moro grammar Monu Naik.
ମୋ ଗ୍ରାମର ମନୁ ନାୟକ ମତେ ଭଲ ପାଉଛି ବାହା ହେବା ପାଇଁ କହି ମୋ ସହ ଶାରୀରିକ ସମ୍ପର୍କ ରଖୁଥିଲା।
Okay.
Now, may I submit, my lord? Yes,
Yes, you are
I am
appearing.
permitted to appear in this case, my lord.
Yes.
Along with my associates.
For a change,
Here is the,
for a
here is the
change your
case.
side.
Admitted it was rejected once, but
Okay.
the statement come before my lord. Is required to be perused, my lord, and the confessional statement, lordship may see.
Yes.
Lordship may see the statement
That's fine. That's
of
submitted on 1/1/2024. 2024. Rejection
Yes.
order was on 21.
Mr. Padi, in fact, your bail plea was rejected on 21/11/2023.
Yes. But what my
Thereafter, 1 minute. Thereafter, what had happened is the now charge sheet is filed on 1/1/2024. Ideally,
Exactly.
you should go to the court of first instance after the charge sheet
But-
is filed.
Yes.
That time investigation was going on, therefore it was rejected.
Rejected.
And
Now
so far
charge
as the
sheet is
other
filed.
so far as the other accused is concerned, I have relegated the petitioner to the trial court to revive the bail plea. I can't pass any other order because I have already.
May
item
I
25.
pray, my lord? Can you lordship keep it to next week? Then I will be with
No,
on
I have
record.
already insofar as co-accused is concerned, I have already passed an order.
And that's
So
why I'm
similar
saying, my
order-
lord. As my lord has already passed an order, that
Huh.
might have they taken this the lower court below. So
Okay,
I have
same
come to
thing.
the my lord on next week. What development is made, accordingly I will appraise the court, because after charge sheet and all these things, suppose some development is made is helpful
But
to me.
I can't pass any other order.
Now I am not instituting part on the order. I am just keeping the my lordship may keep the next week, any Tuesday or Wednesday.
Next time when this matter comes up, you show me that order. Item 25.
Right.
Please it on. Right. Okay. On the
I
request
also
of Mr. Padi,
remember, my lord, that really you are remembering.
Item 20, just item C,
Yes.
item 25. Today's
Yes.
vote. I pass
Yes,
that order. Yes.
My Malan friend has explained. Yes.
That accused was in better footing than the present petition. Because
Yes. Next.
41.
Ma'am, this is in a bail jump case. The petitioner was arrested and he is in custody since 8/1/2024.
Bail jump.
Bail jump. And now, since it is a POXO case.
Apply for fresh bail.
Well,
Apply for fresh bail. Pursuant to the NBW, you have been arrested.
Well,
Apply for bail. Have you applied?
yes, I have applied.
Rejected.
It was rejected. 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 And now the previously the matter was listed.
What was the offense?
Offense was under the POXO Act. Under the POXO Act, and also under SC/ST Act, which is not
Where is the bail order?
Bail order is the lordship can have a glance at the bail order.
Yes.
Which order?
Trial court granted bail you.
No, not high court. Lower court has come.
Oh, that's right.
Man.
And you didn't appear.
There he appeared, but some days he didn't appear, and as a result the NBW was issued.
Trial is going on.
Trial is going on.
Yes. See, initially he was granted bail, but somehow he did not appear, so therefore NBW was issued. He was apprehended and he was arrested
Yes,
now.
right.
And now he's in custody since
since 81 2024.
8/1
2024.
24.
Mal.
8/1 24.
Mal.
On merit, he was already enlarged on bail. So, but how will you assure that you will not further violate the?
Your lordship may impose any condition.
Yeah, all the conditions were imposed, you violated.
What can you?
Why should the court will believe you if this is your conduct?
The trial is going.
Where are you staying, by the way? Let us see.
Staying at village, in the village.
What was the reason of not appearing? Show me. What was the reason not appearing?
But see, he was in search of his deliberate somewhere at Bangalore. He was not available here, and he could not know that.
That means once bail is granted, you will go to Bangalore once again.
But
Then for earning livelihood, then you don't appear in the court.
But
Same thing
he
happened.
couldn't know. He's,
What is the stage? What is the stage of the trial? Do you have any idea?
That instruction is not come, but he is been charge sheeted under the ICS tools.
Victim is victim has already been examined.
Examined. My instruction, the victim has been already examined.
Examined. He is entitled for bail unnecessary. Right now, petitioner is an accused in sole petitioner applied for grant of bail before the trial court. The trial court, by order dated 8/4/2015, enlarged the petitioner on bail with various conditions. Due to violation of the condition and non-appearance before the court, NBW was issued. Pursuant to the NBW, issuance of NBW, the petitioner was apprehended and taken into custody. He applied for bail. Bail on by the order dated 1/2/2024, taken into custody on 8/1/2024. 8/1/2024. He applied for bail by the order dated 1/2/2024. The petitioner, the bail application of the petitioner has been turned down. The petitioner in the bail application pleaded that he had gone to Bangalore in search of his livelihood. Therefore, he could not attend the court, as a result of which the NBW has been issued against him. Since the petitioner was earlier granted bail by the trial court, and for his failure to appear before the court, NBW was issued and he was apprehended by the police and taken him to custody. The petitioner is entitled for bail, subject to condition that the petitioner shall not violate any of the bail conditions. Any of the, what is that order? Bail condition. While repeating the same bail condition imposed by the trial court, the trial court shall release the petitioner on bail with an additional condition that additional condition. What are the additional conditions you want?
Each and every day will be.
That is already there. He shall
lordship is notice.
Failure shall appear before the trial court on each date of hearing. He shall not seek adjournment before the trial court on any pretext whatsoever, and cooperate with the trial court for early conclusion of the trial. This condition, the bail is granted. Yes, next.
42. If I permitted to withdraw.
Yes, withdraw. Yes.
43.
May I please, Your Lordship? Your Majesty, the petitioner is custody, my lord, since 8/1/2023.
8/1.
8/1/2023, my lord.
Yes.
And the alleged offence under section 302/34 of IPC.
CD has come?
Yes, sir.
Yes.
Thereafter, my lord, after completion of the investigation, charge sheet has been filed under section 302, 147, 148, 342, and 149 of IPC.
Yes.
Allegation is that, my lord, on the date of occurrence, my lord, while a family function was going on the petitioner's house, my lord, This deceased entered into the uh, sister-in-law of the petitioner in a naked condition. Thereafter, he has been caught red-handed by these family members and assaulted. For his malord, he has died, as per the allegation, malord.
He was found in a compromising position with the sister-in-law.
No, not compromising position, but he has entered into the house of his sister-in-law, Bhaujo, in a naked condition, my lord. Thereafter, she raised Hala and other family members.
Entering, just he was entering.
Entering nude. So he was beaten up by these people.
They saw that
died.
he is entering for the after the.
How many people?
Altogether, my lord, there are accused 6 accused persons, my lord.
All family members.
Seven, my lord.
What are the injuries?
Injuries, as per medical examination report, my lord, there are multiple injuries, my lord.
Different portion of the body.
There are multiple injuries.
The other portions and
allegation is that
bamboo and lathi was there.
Who is the informant?
Informant is the father of the. Informant is the father of the deceased, my lord. After 2 days of the occurrence, this FIR has been lost.
In a death, in a function of death anniversary of the parental uncle,
My lord.
is going on, he has done it.
Yes. And they have assaulted. Thereafter, they have tied the deceased in a tree. On the morning, he has found dead.
In the morning.
In the midnight.
First they wait in that spot. After that, they
May I read that statement of
there also this one person is
but so far as
they did not give the water also. He was asking water, they are throwing the water, and at night 3 p.m.
You brutally killed him.
Yes.
So far allegation part against
Allegation that's reflecting.
Allegation part, your lordship, allegation part against me, my lord, is concerned. So far as so far as the
one or one amongst the family member, those all of you have beaten mercilessly, tied him in the tree and did not give the water, as a result of which he succumbed to the death in the midnight, merely because he was entering into your sister-in-law's house nude.
There are
without anything, you have beaten up. For what reason? He was drunk, whatever I know, we don't know.
May I read one statement of one of the co-accused, which has been recorded by the police. That co-accused is, my lord, one.
Yes.
Biju alias Kusun Munda, my lord. 11:20 समय पुलिस हेफाजत साक्षी मान उपस्थित मोर बयान देउछि कि गत 15/1/2023 दिन मोर बाहागर थिला मु गोटे झियो घटगाँ एरिया रु आनिथिली तेणु आम बाहागर माइक आउ बॉक्स बाजुथिला मु आउ मोर 3 भाई जथा मंगल मुंडा द प्रेजेंट पिटिशनर माइलर देव आलियास चेमा मुंडा एंड डापु आलियास गुरुचरण मुंडा मोर भिणेई गोबर मुंडा मोर बापा बाया मुंडा घर बाहर नाचुथिलु एही समय मोर सबा सान भाई डापू आलियास गुरुचरण मुंडा देखिला जे जणे के नंगळा है कि मोर बड़ मझिया भाई देव
Yes, slow. It's very slow. Yes. 46.
That's 46. I prefer a pass over Mr. Pandey after lunch.
47.
Well, this is a case of consent. A 19-year-old girl, she says, in a 164 statement, she says that we were in love and he gave me an assurance that he will marry me. Assurance failed. His family members did not agree. So this is the entire tenor of the story. And then she falsely also states that twice she got pregnant, but on medical examination, this was found to be false. And charge sheet also, they have deleted 313. 313. 313.
POCSO is there.
No, POCSO, my lords. When she lodges the FIR, she is 19. She says this has been going on for the last 2 years. So that is why they have included POCSO.
Custody?
Arrested. 15/11/23.
15/11/23.
23.
Yes, so 164 and medical.
Medical kit nahi.
164. Read it.
ମୁଁ 2021 ମସିହାରେ +2 ପଢୁଥିଲି ଏଇ ସମୟରେ ମୋ ସାଙ୍ଗର ମାମୁଁ ହରିଶଙ୍କର ମତେ ଫୋନ କଲେ ସେ ମତେ ଭଲ ପାଏ ବୋଲି କହିଲା ମୁଁ ମନା କଲାରୁ ସେ ମତେ ଡରେଇଲା କହିଲା ସୁଇସାଇଡ୍ କରିବୁ ସେଥିପାଇଁ ମୁଁ ତା ସହ କଥା ହେଲି ସେ ମତେ ଦିନେ ବୁଲିବାକୁ କହିଲା ମୁଁ ମନା କଲି ସେ ମତେ ଜବରଦସ୍ତି ନେଇ ମୋ ସହ ଦୁଷ୍କର୍ମ କଲା 2021 ମସିହାରେ ମୁଁ ଗର୍ଭବତୀ ହୋଇଥିଲି ତାଙ୍କୁ କହିବାରୁ ସେ ମତେ ମେଡିସିନ ଦେଇଥିଲେ ଓ ମୋର ଗର୍ଭ ନଷ୍ଟ ହୋଇଥିଲା ତାପରେ ପୁଣି ଆଉ ଥରେ ମୁଁ ଏଗେନ୍ ଗର୍ଭବତୀ ହେଲି 5 ମାସ ହୋଇଥିଲା ସେ ମତେ ଗର୍ଭ ନଷ୍ଟ କରିବା କହିଲା କିନ୍ତୁ ମୁଁ ମନା କଲା ସେ ମତେ ଜବରଦସ୍ତି ମେଡିସିନ ଖୁଆଇ ଗର୍ଭ ନଷ୍ଟ କଲା ଓ ଅଧା ରହିଯାଇଥିଲା ମୁଁ ମଉସାଙ୍କୁ ଘଟଣା ସବୁ କହିଲି ଆମ ଘର ଲୋକ ହରିଶଙ୍କର ଘରକୁ ଯାଇଥିଲେ ସେଠି ମିଟିଂ ହେଲା ସେ କହିଲେ ତାଙ୍କ ଜେଜେମା ମରିଯାଇଛି ବର୍ଷେ ପରେ ସେମାନେ ବିବାହଘର କରିବେ ତାପରେ ହରିଶଙ୍କର ତାର ବାପା ମତେ ଗୋଟେ କ୍ଲିନିକ ନେଲେ ଯାହା ଗର୍ଭ ନଷ୍ଟ କଲେ ମାର୍ଚ୍ଚ 22ରେ ହରିଶଙ୍କର ମୋ ମୋବାଇଲରେ ସବୁ ରେକର୍ଡିଂ ଦେଖିଲା ପରେ ମୋ ମୋବାଇଲ ଭାଙ୍ଗିଦେଲା ମୋ ଚୁଟି କିଛି ମତେ ବାଡେଇଲା ସେ ତା ପରଠୁ ଆଉ କଥା ହେଲା ନାହିଁ ଏଇ ନଭେମ୍ବର ମାସ 2 ତାରିଖରେ ମିଟିଂ ବସେଇ ମୋ ମା ହରିଶଙ୍କରକୁ ପଚାରିଲା ତୁ ମୋ ଝିଅକୁ ନବୁ କି ନାହିଁ ସେ ମନା କଲା ତା ବାପା କହିଲା ଫିଲ୍ ଦି ୱାର୍ଡ ମୋ ପୁଅ ପାଇଁ ବହୁତ ଝିଅ ଅଛି ମୋ ମା କହିଲେ ତମେ ସେଦିନ କଣ ପାଇଁ ମିଟିଂ ବସେଇକି ତମ ବାପା କହିଲେ ତୋ ଦାନ୍ତ ଝଡେଇ ଦିଅ ହରିଶଙ୍କର ବାପା ଭାଷାରେ ଗାଳି ଦଉଛି ତ ସେମାନେ ମୁଁ କଣ ପାଇଁ ତୋ ଝିଅକୁ ନେବି ହରିଶଙ୍କର ମା କହୁଛନ୍ତି medical report no there is no recent sign of
pregnancy.
Nothing.
She said that twice become pregnant. What is the report?
Charge sheet, that is why they've deleted, and medical report also does not disclose.
Just the medical report insofar as the pregnancy and twice
part is concerned.
medical report
Just check it out.
Victim is not pregnant at the time of examination.
Victim has already been examined.
Medical.
This is a medical.
You are not pregnant that was mentioned
No. In this case victim has already been examined.
Trial started.
Trial is not started.
because rejection on 13/11/23 me
Charge is not yet.
charge sheet filed 11/1/24
11/1/24
mine
Case of consent.
This is a case of consent, my lords. Promise.
No, that's right. But see, your bail application was rejected 30th November, whereas the charge sheet is filed subsequently. You have to renew the bail plea at the court of first instance. I'll record all these things. Okay. Right now, a petitioner is agreed by the order dated 30th November 2023, whereby his bail application was turned down by the additional sessions judge. Come special court under POCSO, Fulbani. Subsequent thereto on 11/1/2024, charge sheet has been filed. Mr. Milan Kangor and senior counsel has taken me to the statement of the victim recorded under 164 CRPC and pointed out that it is a case of all the consensual sex, but the petitioner was 19 years. Therefore, he has been facing this case under Section 6 of POCSO Act. But at the same time, he submits that the petitioner has promised to marry the prosecutrix. Since the petitioner has wriggled out of his promise, the present case is foisted upon him. He also pointed out to the medical evidence and suggested and submitted that the statement of the victim recorded under 164 CRPC is doubtful in view of the medical evidence because the prosecutrix have inter alia stated in her statement that she was pregnant twice and the pregnancy was terminated at the instance of the petitioner. However, the medical record speaks otherwise. Speaks
Not at the time of
that is
NDPS.
his submission. Speaks otherwise.
Yes,
His
similar.
speaks otherwise.
Moreover, my lord,
I
in
get it.
charge sheet, they have deleted
And
330.
that is the reason. That's the reason. In the charge sheet, the offense under section 313 has been dropped. That has been dropped. Be that as it may, since the bail plea of the petitioner was rejected prior to the charge sheet is filed, it would be appropriate for the petitioner to approach the court of first instance and renew his bail plea. If such application is moved, same shall be considered on its merit. You file move the application.
Obliged.
Yes.
Well, it's that matter, that vigilance matter 85. When that part that matter, my lord.
Let us see how
yes.
we are today. We are going very slow.
Yes, my lord. Your
Not even
lordships,
50%.
I think your lordships are fixed up a time, 3 o'clock, my lords.
See, the problem is these bail matters and
I know.
it's sometime.
Yes.
It's lot of time.
Your lordships,
I'll see if it reaches, then I'll take it. Yes.
Obliged.
Matter, sir, it will take time. It requires even that matter, that is a departmental proceeding and criminal proceeding. So, what I pray your lordship may.
Today may not be possible.
But that's why I'm saying that let it come and 23 asu, 23rd asu at 3 PM or
2 PM.
3 PM. Something like it.
3 PM. Because miscellaneous matters are not. Yes.
Much of it.
Yes.
Item 1. May I please? Here I have challenged the order of the cognizance under section 420 and all of the allied offense, my lord.
Yes.
And can I have a glance to page 8, a small affair, where it has been alleged that I such and such stated that I have been deposited 3 lakhs. I have 3 lakhs only in the scheme of microfinance cooperative society LTD.
That's right, but where is the charge sheet?
Cognizance is there. Next page.
Challenge cognizance order, charge sheet you have not filed.
Only one. I have only one.
I can't read the FIR and pass the cognizance order.
No, my humble source, I kindly appreciate one thing. Because the entire allegation is the 3 lakhs, which has been deposited in a particular by a company wherein the present person was a manager. And it is also the case of the prosecution as has been presented in the FIR that one Manoj Kumar Naik was also the agent. Because of the fact that now, my lord, I am submerged, I cannot, because admittedly he has deposited money and it has been due by the company. And I was the manager. And by the person I am employee, whatever my lord, taking my responsibility.
OPID.
No. General. Taking responsibility, my lord, I pray, my lord. Taking all responsibility, my lord, I am ready for, my lord, because the entire amount is 3 lakhs. I am ready to deposit 1.5 lakhs. Let the notice be issued to the other side so that it can be sorted out.
Price sheet once. Price and.
So it can be sorted out. I am ready for 1.5 lakhs. So my bona fide contract, I am ready for.
What is the amount involved?
3 lakhs. 3 lakhs.
3 lakhs, then
another person is there also. I'm not saying that let notice go.
I'll simply issue notice, let us not say anything. Because quashing, cognizance quashing is not, no.
No,
if you settle, pay and come file affidavit, then I can understand. I can't be a party to your settlement process merely because you want
the only province I have also the things has been settled, but the things is insisting for the entire amount. Because I am not in a position to pay the amount. That's my predicament. I do consider, but
the moment I'll write this much, then you say that the court is saying
no, settle out. It will
generally
final order will be passed by my lord.
I'll simply issue notice.
Or may I pay at least 2 lakhs, my lord.
I will not say anything. How without asking him? Who am I?
No, my humble submission, subject to my, because individual is there.
I am simply issuing notice and persuade him and pay and come tomorrow. I'll see if he is agreeing and withdrawing. I'll pass it.
Subject to because the person is also the informant is also suffer. I am also suffering because I am the employee. He is also suffer. That's why, to see the suffering, I have with all much difficulty and arrange around.
Why you want that I should issue notice subject to payment?
Yes.
I am simply issuing notice without money. Without money, you simply issue notice to opposite party.
IA is there, might be considered.
No, issue notice on IA
That's
also.
why my humble submission, subject to deposit of money, my lord, only things can be material.
Cognizance is taken. How can I stay it now?
Offense is compoundable, not that it's not there. Offense is compoundable, he will compound, and by the process also he will get some money. I am not saying that I am giving on charity. I am an employee. I was also.
Show me what is the amount. Show
3
me.
lakhs, remember, page
Where-
8, my lord.
Where is that?
Page 8, my lord, Messi. First, second, third, third line, fourth line from the top, my lord. I such and such, such and such. I have been deposited 3 lakhs only in the scheme of such and such. And it was also portioned by one Manoj Kumar Naik of that same company. But as per the Supreme Court,
It was earlier dismissed.
earlier, no. Once my lord dismissed for default, it is my lord Messi in CLMC number 486 of 2021. Non-appeals dismissed for non-prosecution.
And it restored.
Yes, restored. Now thereafter fresh application filed. CLMC 1660 would have this. Now it has also restored. My lord.
What do you say, Mr. Raghuda?
Notice, madam.
Notice I have issued. He says that application, he seeks stay of the proceeding. Huh?
Stable,
No
NBW
proceeding.
like NBW. Because NBW.
Someone
is-
is there?
No, no.
Someone is
NBW
there.
like
NBW is called.
Yes.
Someone is there?
Execution of NBW. When NBW? Show me.
Someone issue summons for appearance.
No.
fixing-
NBW date. Show me the order. The problem is in your petition, everything has to be presumed. You don't file anything.
My lord, this
Everything has to be presumed and the order.
It was my lord, it was filed about a my lord, some times before. In the-
Show me NBW order. I'll
No courtship order.
show me NBW order, execution of NBW, I'll stay.
All right, my lord, may keep it to Friday. On Monday, coming Monday.
Charge sheet also you file.
Yes, I'll file.
Yes. I'll stay the execution of NBW order subject to paying to about
lakhs.
2 lakh rupees and call him if he agrees.
Yes, madam.
Agrees, if he doesn't agree, then so he is. Yes.
Item 5.
Yes. Adjourn, September.
Item 9.
Yes.
Please, your
Yes.
I'm in custody here since 23/6/2023. A FIR was lodged on 21/6/2023 by my father-in-law, Milord, wherein he alleged that his daughter Bhagyasri had been given in marriage to me on 24/5/2021, and he had complied with all dowry demands, and that after the marriage, the petitioner, his mother, and a neighbor by name Soni, they were torturing her and ill-treating her.
Yes.
And the allegation is that because there was a relationship between this petitioner with Soni, she used to be ill-treated, the lords. And he further says that on the date of incident, he had been to the house of his daughter had cried, and after consoling her, he had returned back, and thereafter they got an information over phone that the daughter was serious, and when they went, they found her dead in Pipli hospital there. And the FIR was lodged. The investigation was taken up, and it was found that the allegations against Soni and the mother-in-law would not be substantial.
You have the CD? Yes.
So charge sheet has been filed only against this petitioner, alleging commission of the offences and sections 498A and 320. Now, my lords, the evidence on record does not establish that the petitioner was present in the house on that day. In the FIR, his presence is not noted. In the statements under 161 also, my lords, there is nothing to show that the petitioner was present and he was responsible for the death. If I am permitted to place the statement of the informant, that's ବୟସ so and so ଇତ୍ୟାଦି। ଆଜି 21/6/23 ଦିନ ଆପଣଙ୍କ ନିକଟରେ ଦେବା ବୟାନ ନେଇକି ଯେ 5/21 ରେ ମଙ୍ଗଳପୁର
You are reading 161.
yes
But these witnesses have already been examined by the.
no, these witnesses have not been examined. The witnesses who have been examined, they have not supported the prosecution.
PW1 to PW7.
Yes.
None of them have
supported the.
Who are they?
They are neighbors, my lord.
Okay. Whose 161 statement you are reading?
I am placing the statement of the informant.
Informant. He has not been examined.
He has not been examined, but even neither he has stated about my presence in the FIR nor in his statement. That's what I am trying to impress.
Which statement? FIR and 161.
Yes.
Yes. Yes.
What he states is this. ବିବାହ ସମୟରେ ବର ଘରର ଦାବି ମୁତାବକ 1,20,000 ଟଙ୍କା ସହ ସୁନା ରୂପା ଗହଣା ସହ ଖଟ ସୋଫା ଟିଭି ଫ୍ରିଜ ଫର୍ଣ୍ଣିଚର ଦିଆଯାଇଥିଲା। ବିବାହର 2-3 ମାସ ପରେ ମୋ ଝିଅ ତାର ସ୍ୱାମୀ ସମୀରଣ ଆଉ ଗୋଟେ ଝିଅ ସହ ସମ୍ପର୍କ ରଖିଥିବା କଥା ଜାଣି ସମୀରଣକୁ ପଚାରିବାରେ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ମଧ୍ୟରେ ପାଟିତୁଣ୍ଡ ହୁଏ। ସମୀରଣ ଏ କଥାକୁ ନେଇ ମୋ ଝିଅକୁ ମଧ୍ୟ ବାଡ଼େଇଛି। ଝିଅ ଭାଗ୍ୟଶ୍ରୀ ଏ କଥା ଆମକୁ ଜଣାଇଲା ପରେ ମୁଁ ତାଙ୍କ ଘର ମଙ୍ଗଳପୁରକୁ ଯାଇ ଭଦ୍ରଲୋକମାନଙ୍କ ସାହାଯ୍ୟରେ ସମାଧାନ ଦେଇଛି। ବାରମ୍ବାର ଆମ ଜ୍ୱାଇଁ ସମୀରଣ ଝିଅ ଭାଗ୍ୟଶ୍ରୀ ସହ କୌଣସି ସ୍ୱାମୀ ସ୍ତ୍ରୀ ସମ୍ପର୍କ ରଖିନଥିଲେ। ଯେହେତୁ ଝିଅର ନୂଆ ନୂଆ ବାହାଘର ମାତ୍ର 2 ବର୍ଷ ହବ ମୁଁ ତାଙ୍କୁ ସମୟ ଦେଉଥିଲି, କାରଣ ମୁଁ ଭାବୁଥିଲି କି ସେ ବଦଳିଯିବ। ମୋ ଝିଅ ଉପରେ ତାର ଶାଶୁ ସୁଚିତ୍ରା ଏବଂ ସମୀରଣ ସହ ପ୍ରେମ ସମ୍ପର୍କ ରଖିଥିବା ଝିଅ ସୋନି ସବୁବେଳେ ତାଙ୍କ ଘରକୁ ଆସେ। ସମସ୍ତେ ମିଶି ଝିଅକୁ ବହୁ ମାନସିକ ଶାରୀରିକ ଯନ୍ତ୍ରଣା ଦିଅନ୍ତି। ସମୀରଣ ଟିକେ ଟିକେ କଥାରେ ଝିଅକୁ କହେ ତୁ ଛୋଟ ଘରର ଝିଅ, ତୁ ଅସୁନ୍ଦରୀ, ତୁ ମରିଗଲେ ମୁଁ ସୋନିକି ବାହା ହେବି ବୋଲି ସଦାବେଳେ କୁହେ ଓ ଝିଅକୁ ବାଡ଼ିଆ ମରା କରେ। ଏସବୁ କଥା ବହୁତ ଥର ମୀମାଂସା ହୁଏ। ସମୀରଣର ବାପା କାଶୀନାଥ ଏସବୁ କଥା ସଦାବେଳେ ସହି ନପାରି ଆତ୍ମହତ୍ୟା କରିଥିଲେ। ଗତ ମାସରେ ମଧ୍ୟ ସ୍ୱାମୀ ଶାଶୁ ସୋନି ମିଶି ମୋ ଝିଅକୁ ବାଡ଼େଇବାରେ ମୋ ଝିଅ କ୍ଷତାକ୍ତ ହୋଇଥିଲା। ମୁଁ ବୁଝେଇ ବାଝେଇ ଆସିଥିଲି। ଆଜି ସକାଳେ ମୁଁ ଏବଂ ମୋ ସ୍ତ୍ରୀ ଆମ ଜ୍ୱାଇଁଙ୍କ ଘରକୁ ଯାଇଥିଲୁ ଝିଅକୁ ଦେଖିକି ଆସିଲି। ମୁଁ ଆସି ଘରେ ପହଞ୍ଚିଛି, ଫୋନ୍ ଆସିଲା ତୁମ ଝିଅର ଦେହ ବହୁତ ସିରିୟସ୍ ଅଛି, ଜଲ୍ଦି ଆସ। ଆମେ ଆସିଲା ବେଳକୁ ସେମାନେ ପିପିଲି ହସ୍ପିଟାଲ ନେଇଯାଇଥିଲେ। ଆମେ ଯାଇ ସେଠାରେ ଦେଖୁ ଝିଅର ମୃତ, ତାର ଆଖିକି ମାରି ଆଖି ଭିତରେ ଅବସ୍ଥାରେ ହସ୍ପିଟାଲ ବରଣ୍ଡାରେ ପଡ଼ିଛି। ଝିଅର ଦେହ ସାରା କ୍ଷତ ଚିହ୍ନ ଅଛି। ମୁଣ୍ଡ, ମୁହଁ, ଛାତି, ହାତରେ ମାଡ଼ ମାରି ସିଝେଇ ଦେଇଛନ୍ତି।
How do you say that he was not there?
He doesn't say.
He doesn't say.
He doesn't say in the FIR about his presence. He doesn't say in his statement about presence. His wife doesn't say about his presence. I am an employee of SBI Credits. I am posted at Cuttack. That is the evidence. And if I was not present there on
charge sheet says.
Charge sheet also doesn't say that. I am placing the charge sheet.
Charge sheet says that you.
I am placing
you
the
are in
charge
Cuttack.
sheet.
You are.
I am placing the charge sheet bills. On 21/6/2023 at 7 p.m., complainant alleged that on 24/5/2021, Bhagyasri, his daughter, had married Samir alias Alok, son of late Kasinath, as per Dwara Vivaha ritual. At the time of marriage, cash of 1,20,000, gold and silver ornaments, other household articles had been given as dowry as per demand of her in-laws family. 2-3 months after the marriage, husband, mother-in-law Suchitra and a girl namely Soni of their neighborhood started torturing her. Soni has a love relationship with accused who regularly came to their house, joined her hand with them. Her husband and mother-in-law tortured her regularly in silly matters, do not give her food, also assault. Due to this, complainant and gentries had settled the matter several times. When father of Alok came to know the relation of Alok and Soni, he protested them, but when they paid deaf ear to him, he committed suicide.
Yes, I understand. Yes.
This is not spoken to by anybody.
What do you say?
Madam, there are, my lord, 14 injuries on the body of the deceased, my lord. And cause of death, my lord,
He is the only accused.
Only accused, my lord. Death due to asphyxia as a result of a smothering and violent compression of a neck. And with regard to that, my lord, in charge sheet, my lord, I am reading out the last portion of the charge sheet, my lord. Even he went to the extent that assaulted a Bhagyasri in form of a fist blow and kick blows. Out of anger, he pushed Bhagyasri, as a result of which he fell down on the edge of the staircase and sustained a head injury on the backside of her head. Subsequently, he compressed the petitioner compressed the neck of Bhagyasri and also compressed the nasal layer windpipe, resulting her death.
This
is charge sheet, my lord.
Who has said so?
Though the one of the witness, though he has already been examined, but not supported the prosecution case, my lord. One Lakshmandra Barik, my lord. He stated that a relevant person, Suchita Jodi Virodha Kare,
But the 161 has no meaning, na? He has been examined.
My lord.
Didn't support.
ଘଟଣା ଦିନ ସୁଚିତ୍ରା ସାହୁ ସ୍କୁଲ ଯିବା ପରେ ସମୀକରଣ ଓ ତାର ସ୍ତ୍ରୀ ତାଙ୍କ ଘର ଭିତରେ ପାଟିତୁଣ୍ଡ ଲାଗି ସମୀକରଣ ତା ସ୍ତ୍ରୀ ଭାଗ୍ୟଶ୍ରୀକୁ ବାଡାବାଡି କରିଛନ୍ତି ଏଥିରେ ସନ୍ଦେହ ନାହିଁ ସୋନି ଅଧିକ ସମୟ
এটা ওটা opinion
whether he is available on the particular date.
No, this witness which you read, he has already been examined. He did not support the case.
Did not support the case, manner.
ତାକୁ hostile ବି କରିନାହାନ୍ତି.
Leave 161.
With regard to statements of her father, my lord, that is, it is admitted fact there was a quarrel between them, and the due to extramarital relations, she torturing the accused, tortured the deceased, and also assaulted, and her assaulted her. For that reason, the father.
How many witnesses are there? Here,
total witness 25 witness, man. 7 witnesses only examined. After examination, my lord,
who all are the material witnesses according to you?
The father and family,
informant,
all the family members, my lord.
All family members, who all are?
Of the deceased.
Who all are they? Those who
father,
mother were not there. After receiving the news, they came.
Nobody was. No, there is no material witness left.
With regards to other offences, there was a prior to the death, my lord, the petitioner having extramarital
relations. Charge sheet मना करती कहले the evidence is not found. How is it admitted?
As per evidence of the father of the deceased.
Your lordship may see the charge sheet.
You examine the
father of the deceased.
Father of the deceased.
Your lordship may permit me to place the charge sheet. The charge sheet shows during investigation and supervision, there is no evidence to substantiate the charge against Suchitra Sahu, mother of accused Samir alias Samira. So far, no evidence is established against the other affair named accused, Soni alias Priyanka Sarma. And how is it admitted, as my learned friend is saying?
No.
That there is
after 2 months, I am reading out from the charge sheet. After 2 to 3 months of the marriage, Bhagyasri suspect the character of the accused.
No, that is the allegation.
But there are allegations, my lord.
But after investigation, this was found.
Father also elaborated his evidence that.
When were you going to examine? I'll keep it after 2 weeks. 2 weeks, after 2 weeks. Mr. Agadar and counsel for the petition respondent says that the informant in the case is likely to be examined shortly and lease the matter after 2 weeks. Within 2 weeks, informant kar do, then he is entitled. Examine the informant. And all the independent witnesses have not supported you. What will you do?
In front of Manodan Das.
Wrong or right? You are reading 161 statement of those witnesses, those who have been examining the court, and they did not support you. That 161 is neither here nor
now should be changed.
See, ultimately, if you can convict on the basis of material, then he can be retained in the custody. Otherwise, right or wrong, you are not able to.
They made so many amendments. They should have changed the rules regarding bail. That they did not do, for which my learned friend is taking action.
Just put it after 1 week, so that just check it, informant, when you are going to. Otherwise, you don't have any material. Allegations are serious, but there is no material. What to do? 7 witnesses, independent witnesses, have not supported you.
All of them are below to the.
Hostile करचे एकदम.
That's the problem.
गवर्नमेंट के लोग आमर ना तुम्हारो.
Yes, next.
16.
At the end of the day, except the informant, nobody would support the proceeding.
In front of the family person, why conversation?
That's the whole difficulty with it. Yes.
May I please for a loss?
Yes,
My lord,
yes.
the petitioner custody since 21st April 2022 and allegation against 302 IPC Millard. The allegation Millard on on 21st 4/22 Millard, one Gedo Murmu lost affair narrating his cousin brother of Lasa Hemram, the present petitioner, reside with his mother Gurubari and grandmother Mali Hemram at his
CD?
home.
CD available.
Available.
Yes.
Ready?
Yes.
Yes.
It is alleged that on 20th March 2022, night Lasa Hemram, the present petitioner, quarreled with his mother and assaulted by means of an axe. As a result, she succumbed to the injury.
You killed your mother.
My lord, it is purely a matter of trial, my lord. My lord, first of all, the accused is the son and the deceased is the mother. And the eyewitness is there, the grandmother of a petitioner and the mother of the eyewitness.
Deceased.
My lord, deceased mother eyewitness. And eyewitness stated there that, may I read the only relevant part, my lord? ମୋ ଘରେ ଚକୁଳିଆ ଗ୍ରାମରେ ଦେବା ମୋର ମୌଖିକ ନେଇକି ଯେ ମୋର 4 ଝିଅ ସେଥିମଧ୍ୟରୁ ଦାନଗୀ ଗୁରୁବାରୀ ହେମ୍ବ୍ରମ ଡିସିଜ୍ଡ ଚକୁଳିଆ ଗ୍ରାମରେ ରୁହନ୍ତି। ଗୁରୁବାରୀ ହେମ୍ବ୍ରମର ଜଣେ ତାର ପୁଅ ନାମ ଲସ୍ ହେମ୍ବ୍ରମ ଦିସ୍ ପିଟିସନର ସେମାନଙ୍କ ସହିତ ରୁହେ। ମୋର ଦେହ ଖରାପ ଥିବାରୁ ମୁଁ ଚାଲିପାରେ ନାହିଁ। ମୋ ଝିଅର ପୁଅ ଲସ୍ କାମ କରେ ପକ୍କା ମିସ୍ତ୍ରୀ। ମଝିରେ ମା ପୁଅ କଳି ଲାଗନ୍ତି। ଘରରେ ରୋଷେଇ ଓ ଅନ୍ୟ କଥାକୁ ନେଇ କାଲି ତା 24/22 ତାରିଖରେ ଲସ୍ ତା ମା ସହିତ ଖାଇବା କଥାକୁ ନେଇ କଳି ଝଗଡ଼ା ହେଲା। ତାପରେ ତା ମା ଗୁରୁବାରୀକୁ ଘୁଷୁରି ନେଇ ଗୋଟେ କୁରାଢିରେ ବାଡେଇ ମାରି ଦେଲା। ମୁଁ ମନା କରିବାରୁ ମୋତେ ମଧ୍ୟ ପିଟିଲା। ମୋ ଦେହ ଖରାପ ହେବାରୁ ମୁଁ ଚାଲି ପାରୁନଥିବାରୁ ମୁଁ ମୋ ଝିଅ ଗୁରୁବାରୀକୁ ବଞ୍ଚେଇ ପାରିଲି ନାହିଁ।
Yes, what do you say?
ମୋ ଝିଅର କିଛି କଥା
Statement of the informant I am taking.
You have killed your mother and there is eyewitness who is your grandmother.
Eyewitness
And also, my lord,
committed to the Court of Session since 22 Millard. In the meantime, Millard 24, none of the witness has been examined.
No, this eyewitness is examined.
Tribal
My
people,
lord,
your lordship.
Eyewitness examined.
No, my lord, that instruction I have not, my lord.
No.
My lord, your lordship
Since
kindly
two-
just, I am only saying 2 sentences, my lord. According to the 27 confessional statement, my lord, the weapon has been leading to discovery by this accused petitioner. And also, the postmortem report, the cause of death due to the severe hemorrhage, shock due to the injuries on vital organ of brain by sharp cutting weapon.
Yes.
And nature of death is
You
homicide.
wait till that old lady is examined.
Yes, your lordship.
Petitioner
Keep it next
rejected
week.
by, petitioner rejected by the order dated rejection of the kind order dated order dated 28/11/2023 passed by the additional district and session judge Baripada in ST case number 515 of 2022, whereby bail has been rejected. The allegation is that the petitioner has assaulted the mother, which has been eyewitnessed by the grandmother of the petitioner. And the statement of the sole eyewitness grandmother has not yet been examined. Therefore, I am not inclined to grant the petitioner bail at this stage. However, the petitioner is given liberty to renew his bail free after the eyewitness is examined by the court with this observation. The petitioner.
Last time, Malahindram.
Next.
Within your lordship time.
We will do it. We'll see. Next.
44.
It will be your mother and you.
Renew his prayer thereafter. Your lordship. Thanks. Liberty.
Charge sheet submitted, my lord. 498/306 charge sheet submitted, my lord. And a case of hanging 22 years after, my lord. Marriage 22 years. It was filed, my lord, since January, my lord. 30th January, my lord. I have the certified copy of the entire, my lord. PM also.
all the things, my lord. 498 306, my lord. And 22 ବର୍ଷ ପରେ she committed suicide and FIR has been registered. Only for there is no 4DP Act, my lord. Your lordship kindly peruse the charge sheet, my lord.
The prosecutor is also not entitled to see the CD.
Entitled, my lord, since January I have filed, my lord, till today.
Right.
Twice your lordship called for the case diary, my
No,
lord.
there is no direction.
Earlier there is a direction, my lord.
What
Twice
is
your
the
lordship
problem?
directed.
April it is direction is made. Why have you not got it? Huh? See, this matter is taken up many time, you know. March, April, and
all the CD
May.
available except this case. All the CD available.
1 week only I am giving.
Yes, it is.
Good week chhadi next week. By
Date-
the last and final opportunity, the State
Miller.
Council is granted one more opportunity to avail the CD, release the matter.
Right.
And in the meantime, let the counsel for the petitioner to file the
Charge sheet.
charge sheet copy.
Yes.
You file the charge
Your
sheet-
lordship. Yes, I will file
you file
today,
the
my
charge-
lord.
1 minute, you file the charge sheet copy. Even if he doesn't get the CD, I will decide on.
Yes, my lord. Keep it on 13 or 14th, my lord.
Keep it, huh?
14. Keep it. 45.
45.
May I please, your lordship? Petitioner is in custody, my lord, 16/10/2023. Unknown affair was registered. Thereafter, while the investigation was going on, one statement was
Offense?
offense, my lord. Charge sheet submitted. Initially, case was registered 365, my lord.
When charge sheet registered?
Charge sheet submitted on 30/12/2023, my lord.
30.
30. December 30th December, my lord, 23.
Yes.
For alleged offense, my lord, 364/201, 302, 120B, 212/34 of the IPC, read with the 25(1)(a) of the Arms Act. So far as the present petitioner is concerned, my lord, the statement of one witness, my lord, he has seen, my lord, Bhagavan Parida, my lord. I am read out the statement of Bhagavan Parida, my lord. The ଆଜି 14/10/2023 ରିକରେ ଆପଣଙ୍କୁ ଦେବା ମୌଖିକ ବୟାନ ହେଇକି ଯେ 6/10/2023 ରିକ 12:50 ସମୟରେ ମୁଁ ମୋ ଘର ଆମ ଗାଁ ଛକକୁ ଆସୁଥାଏ। ଠିକ ଏହି ସମୟରେ ଆମ ଗାଁର ସଂଗ୍ରାମ ପରିଡ଼ା ଓରଫ ସଙ୍ଗୀ ପିତା ସ୍ୱର୍ଗତ ମଙ୍ଗୁଳୁ ପରିଡ଼ା, ବଳରାମ ଓରଫ ହୀନ ସେଠୀ, ସାନିଆ ସେଠୀ, ଚନ୍ଦନ ସେଠୀ, ଲିଟୁ ନାହାକ, ଭ୍ରମର ପାଣ୍ଡି ପିତା ସ୍ୱର୍ଗତ କଣ୍ଡୁରୀ ପାଣ୍ଡି, ସଞ୍ଜୟ ରାଉତ ପିତା
See, your
ପଦ୍ମ
bail
ରାଉତ।
application rejected on 8/12/2023. That time investigation was going on. Subsequently, charge sheet is filed.
Charge sheet immediate thereafter, my lord.
Filed. So
Charge sheet
therefore-
submitted. So far as the
therefore go to-
petitioner, there is
Go
no,
to the court of first instance.
there is no direct allegation so far as the petitioner is concerned. Only allegation is that who has seen the occurrence, my lord, he has not uttered my name, my lord. Only some
You are referring for?
some article which has been seized from my house.
This
I
is
have been
actually to give
implicated.
evidence in one criminal case. The accused and his other friends, they committed this crime, and after kidnapping, the manner they have committed, they have assaulted, and that assault part they have shown in video call.
No, so far as the
The petitioner has approached the court below for grant of bail. The charge sheet, the trial court rejected the bail application on 8/12/2023. Subsequent thereafter, on 30th of December 2023, charge sheet has been filed. In the changing circumstances, the petitioner should approach the court of first instance for grant of bail. Therefore, I am not inclined to entertain this petition. However, liberty is granted to the petitioner to approach the trial court a fresh for grant of bail. This observation.
But so far as what happened, my lord, I have approached this honorable court on February, my lord. February, 20th February, my lord.
Should have gone there only because charge sheet is
My
filed.
charge during that time, my lord, charge sheet submitted. So far as the petitioner, some
Anyway, next item.
My lord, I'm for the sub item.
I have not.
I'm for the sub item.
Both the
No,
matters.
I'm after charge sheet, I'm renew.
After charge sheet?
Yes, my lord.
Yes.
The rejection order, my lord.
After
Rejected
yes.
on February, my lord.
No, February.
13 to
Yes, tell me,
24.
what is your
My lord. The eyewitness statement, my lord. I'm reading.
You are
Bhamar Pandi.
Parmara Pandit.
Bhamar Pandi.
What are the allegations?
The eyewitness, my lord, who is the accompanied with the deceased, my lord.
Yes.
And I'm reading the statement, my lord, Satya Patra. To the eyewitness. 6/10/2023 ତାରିଖ ଦିନ ପ୍ରାୟ 3 ଘଣ୍ଟା ସମୟରେ ମୋ ସାଙ୍ଗ ଦୀପୁ ପାତ୍ର କୋଦଳା ଏଡିଜେ କୋର୍ଟରୁ ଏସଟି କେସ୍ ନମ୍ବର 3 ରେ ଉପସ୍ଥିତ ଥିବାର କୋଦଳା କୋର୍ଟରୁ ଆସିଥିଲା। ଏବଂ ଦିନ 3 ଘଣ୍ଟା ମଧ୍ୟରେ ଆମ ନିଜ ଗ୍ରାମକୁ ଫେରିବା ବାଟରେ କୋଦଳା ଛଚିନା ସାତନ୍ତଳା ଛକ ନିକଟରୁ କୋଦଳା ଥାନା ଅନ୍ତର୍ଗତ ଜଗନ୍ନାଥପୁର ଛଚିନାର ସନିଆ ସେଠୀ, ହୀନ ସେଠୀ, ସଙ୍ଗୀ ପରିଡ଼ା, ଚନ୍ଦନ ସେଠୀ, ଚନ୍ଦନ ରାଉତ, ଲିପୁନ ନାୟକ, ବାବୁ ଆଲିଆସ ରାକେଶ ପରିଡ଼ା, ଆଲୋକ ପ୍ରଧାନ, ସଞ୍ଜୟ ରାଉତ, ଲିଟୁ ନାହାକ, ବବୁଲ ଗୌଡ଼, ଭୂତ ଆଲିଆସ ଉତ୍ତମ ବିଶ୍ୱାଳ ଓ ଅନ୍ୟମାନେ ଦୀପୁକୁ ଅଟକାଇ ଯାଇ ତାର ମୋବାଇଲ ବନ୍ଦ
Your name
କରିଦେଲେ।
is not there.
No, my lord. And my lord, another eyewitness, my lord, ସେମାନେ କଣ ତା ହ୍ୱାଟ୍ସଆପ୍ କଲ୍ କରିକି ଆସଲ୍ଟ କରିଥିଲେ। ତାର ବି ଷ୍ଟେଟମେଣ୍ଟ ଅଛି। I have not asylum, I have not named,
You are not.
not named, not.
Yes. What do you
But
say?
as for charge sheet, my lord.
Receiving submission, my lord, one Gopal Nath.
See, don't tell me the story. So the eyewitnesses says that the eyewitness has taken name of many people, but this petitioner name is not there. And other eyewitness says that I have called in the WhatsApp call to reach in the spot. By the time incident had happened and
No, my lord,
the witness was not.
on WhatsApp call, she seen the accused person who assaulted the deceased person. She named them.
What is the what are the materials? Have you seen it then that light?
Miller. First, Miller, CD reveals, Miller, in CCTV camera, Miller, he was there, Miller. Subsequently, one statement, Gopal.
This petitioner is there.
Yes, that is mentioned, Miller. Verified CCTV camera village of medicines are found intact out all the accused person who kidnapped the Dipu Miller. That is mentioned, Miller, in the CD, Miller.
In charge sheet, my lord, I'm
1 minute, Miller. So to one Gopal Nahar, his category taken his name, Miller. He has stated, Gopal Nahar, 6-10 ଦିନ 12 ଘଣ୍ଟା ସମୟରେ ଭାଇ ଦୀପୁ ପାତ୍ର କୋଦଳା ଏଡିଜେ କୋର୍ଟରେ କେସରେ ଉପସ୍ଥିତ Yes. 16-10-23 ତାରିଖରେ ମୁଁ ଜାଣିବାକୁ ପାଇଲି ଯେ ଗତ ତା 10 ତାରିଖରେ କୋଦଳାକୁ ଆସିଥିବା ନିଜ ଗ୍ରାମକୁ ଫେରିବା ବାଟରେ କୋଦଳା ସାତନଳା ଛକ ନିକଟରୁ ଥାନା ଅନ୍ତର ଜଗନ୍ନାଥପୁର ପାଖରେ ସନିଆ ସେଠୀ, ଲିଟୁ ନାହାକ ଓ ଭ୍ରମର ପାଣ୍ଡିଆ ଭ୍ରମର ପାଣ୍ଡି, ଆଲୋକ ପ୍ରଧାନ ଅନ୍ୟମାନେ ତାକୁ ଅପହରଣ କରି ନେଇଗଲେ।
He is not eyewitness, my lord. ଜାଣିବାକୁ ପାଇଥିଲେ। He is not the eyewitness, my lord. He is not the eyewitness. ଜାଣିବାକୁ ପାଇଲି।
Seen kidnapping?
No, my lord. ଜାଣିବାକୁ
he was killed.
No, my lord. ମୁଁ ଜାଣିବାକୁ ପାଇଥିଲି ଯେ not
And
eyewitness.
after kidnapping, the manner
And
of
my
assault was shown to another friend who is living in Surat through video call. You see,
Yes,
the
yes,
result of giving deposition against us. Because that deceased had been to depose in another case.
Wait till
he was a witness.
My lord, as for charge sheet, my lord, as for charge sheet,
I'm
I'm
not being held to the nature of crime and allegation made against the petitioner. I'm not inclined to grant enlarge the petitioner on bail at this stage. However, the petitioner can revive his bail application after the eyewitnesses are examined by you. And the same thing you will do if this you are granted bail and you will
name the.
Danger to the all the eyewitnesses. Yes.
No, I did not name the
After
so.
the eyewitnesses. Yes, next.
I don't.
46.
I'll have to withdraw. Wouldn't move after.
Counsel for the petitioner seeks to withdraw this petition. Dismiss as become.
Oh, bless you.
Lords, here I am in custody since 7/9/2023. I have been charge sheeted on 14/12/2023 under 363, 366, 376 2N and 6 of the POCSO Act. If the 164 statement of the victim is gone through, your lordship will find that it's a case of consent and the medical report doesn't corroborate the allegations of.
Yes. No, 160.
4.
Yes, read it.
She says, बलांगीर कोर्ट रे उपस्थित एई बयान देउछि जे मु तपस्विनी पोड़ तनु रतेई को भल पाउथिली आज को प्राय 6 वर्ष हेबो तनु आम गाँ को दंड नाचिया पे आसथिला एवं सेठारु आम भितरे प्रेम संपर्क गढ़ी उठिला तनु मते भलरे रखियो बोली कहिला टंका एवं सुनार लोभ मध्य देखाइला आमे प्राय 1 वर्ष तळे फोन रे कथावार्ता हेउथुलु तारीख 10/7 राति रे तनु आम घर को आसला मते ता संगे जीवा पे कहूला मु तनु को भल पाउथु हेतु विश्वास करी गली आमे आम गाँ रु केसिंगा गलु सेठारे प्राय 55 दिन रहिलु केसिंगा रे 15 दिन रहिबा समय रे तनु मो सह शारीरिक संपर्क रखिला तापरे से मते ता घर कुकुटी को नेला कुकुटी जीवा परे मु जानिया को पाइली जे तनु विवाहित एवं तार पिला मध्य अछंती तनुर स्त्री मते सेठारे रहिबा पई कहिला मु 6 मास परे गर्भवती हेली फल मते जोर जबरदस्त तनु एवं ता स्त्री बटिका खुआई गर्भ नष्ट कले तनुर स्त्री
The wife of Tanu is also an accused.
No, she is not an एवडाकर किछि मटेरियल पाइलेनी 313 रे चार्ज शीट हिनी मेडिकल रिपोर्ट डजंट corroborate
Never pregnant. Yes.
Here, Milord, date of birth, Milord, 14/2/06, Milord. Occurrence 22. At the time of the admittedly 16 years, Milord. Person, in percentage himself as a unmarried person, Milord, get physical relationship, Milord. This is the case.
मेडिकल रिपोर्ट कहू फिजिकल रिलेशनशिप अछि
Statement of victim is sufficient, not necessarily medical report. Yes. It inspire confidence, Milord.
निश्चित
Forcibly aborted. Any evidence got?
That is the charge sheet 313 is not there. That I am not permitting, Milord. But admittedly, when he was a minor, Milord, present petitioner concealing its status as a married, Milord, get physical relation. This is my statement.
That's right. That is
Yes.
there.
Now, I have a submission, Milord.
That is there.
We are governed under that is called Evidence Act, and the new act has come. But my learned friend is speaking as though the thief carrying the Brahmin carrying the cow became a donkey and he threw it. That is the submission. So your lordship may consider the lady's submission is this, that she has voluntarily accompanied.
What is the stage?
Take the charge sheet file and 14/12/23, Milord. 14/12/23 charge sheet file.
Examine this with
Milord.
prosecutor.
Lordship direct.
How much? 3 months?
Yes.
2 months or 3 months?
3 months, Milord.
3 months.
Milord.
3 months.
Is he making this submission with instructions or out of his
I
hat?
will say that.
No, Lord, is he making the submissions out of his hat or?
Obviously, instruction.
Let him take instructions. What is the stage, my lords?
No, he says that prosecutrix will be examined. Charge it has
No,
already
who
started.
denies that the prosecutrix will not be
As a
examined?
first witness.
But when will the prosecutrix be examined?
3 months, otherwise.
Only when she appears.
Within 3 months, otherwise you will revive. Either of this, whichever is earlier. Whichever is earlier. That's what I'm going to do. Whichever is earlier. On instruction, I'll say 3 months, you will revive. Or the witness is examined, whichever is earlier, you will revive. Or you seek instruction and tell me, definitely. I'll issue notice. A notice is already issued. CD has come.
I'll after instruct regarding stage of this trial.
The State Council seeks 1 week time to go get instruction regarding the stays up for the regarding the status of the trial, at least after 1 week.
Miller.
Get it, huh?
Miller.
Yes. And how many witnesses are there total?
Total again.
16.
By C.
Material witness maybe to 1 2.
Miller.
Yes. Next. Yes. Which is which one?
74.
We are there, item 74. Matter has been settled between the parties. It's a matrimonial discord. The husband and wife, everybody is present. The family members.
Information
Just call
BCO
them.
also.
Where is it? 74.
I'll just call them.
Huh?
I'll just call
You
them.
call
right
them
after.
and tell me.
Yes.
Yes, next. Yes.
My lord, item 48.
Hmm.
May I clear also? My lord, offense under section 302. The petitioner is inside custody since 6/9/2023. There are 26 charge-sheeted witnesses, but none of them are eyewitness, my lord. My lord, have a glance to page number 32.
Yes.
May I read, my lord?
Yes.
ମୁଁ ଉପରୋକ୍ତ ବ୍ୟକ୍ତି ଆଜି 4/9/2023
What are the allegation against you? 302.
My 302, my lord. My lord, deceased came to my house and consumed some liquor. After that, the quarrel arose between the petitioner and the deceased. And after 10 hours, at 11 hours, the deceased died. That is the allegation, my lord.
I'm placing the Miller substance evidence Miller against him. Last in theory Miller, extrajudicial confession and leading to discovery.
Extrajudicial. My lord, have a
Last
glance
in theory one Miller Sanjit Musa.
What is the stage?
Sanjit Musa, my lord.
Right.
Charge sheet file 24/12/23 Miller. 24/12/2023. 24/12/23.
My lord, have a glance to that page number 32, my lord, that Sanjit Musa. ମୁଁ ଉପରୋକ୍ତ ବ୍ୟକ୍ତି ଆଜି ତା 4/9/2023 ତାରିଖରେ ଆପଣଙ୍କ ନିକଟରେ ଦେବା ମୋର ମୌଖିକ ବୟାନ ଏହିକି ଯେ ତା 30/8/2023 ତାରିଖରେ ମୁଁ ଗାଈ ଚରେଇ ଯାଇଥିଲି। ସନ୍ଧ୍ୟା 5 ଘଣ୍ଟା ସମୟରେ ଗାଈ ଆଣି ଘରେ ବାନ୍ଧିଲି। ମୁଁ ଛେଳି ଲେନ୍ଦି ଗାଁର ରମେଶ ବାରିଙ୍କୁ ଜାଣେ ଓ ସେ ସନ୍ଧ୍ୟା 5 ଘଣ୍ଟା ସମୟରେ ଆମ ଗାଁ ଦାଣ୍ଡରେ ବୁଲୁଥିବାର ଦେଖିଛି। ସନ୍ଧ୍ୟାରେ ମୁଁ ଆମ ଗାଁ କୋଠ ଘର ନିକଟକୁ ଯାଇ ରାତି 9 ଘଣ୍ଟା ସମୟରେ ଘରକୁ ଫେରିଲା ବେଳେ ଦେଖିଲି ଶିବ ସାହୁ ପିଟିସନର ମାଇ ଲର୍ଡ ଘର ସାମ୍ନା ରାସ୍ତାରେ ଆମ ପାଖେ ପାଣି ଟେପ୍ ନିକଟରେ ରମେଶ ବାରିକ ଚିତ ହୋଇ ପଡିଥିଲା ଓ ରାସ୍ତା ଉପରେ ଶିବ ସାହୁ ଠିଆ ହୋଇଥିଲା। ଉକ୍ତ ଶିବ ସାହୁ ମତେ ଆମ ଗାଁ ନିକଟରେ ଛେଲେଣ୍ଡି ଗାଁର ରମେଶ ବାରିଙ୍କ ଘରେ ଏହି ଖବର ଦେବା ପାଇଁ ଅନୁରୋଧ କଲା। ତାପରେ ମୁଁ ଛେଲେଣ୍ଡି ଗାଁକୁ ଯାଇ ରମେଶ ବାରିକ ସ୍ତ୍ରୀକୁ କାକା ରାସ୍ତା କଡ଼େ ପଡିଥିବା କହିଲି। କାକି ମତେ କହିଲେ କି ତୁମ କାକା 3-4 ଦିନ ହବ ବାହାରେ ଶୋଉଛନ୍ତି, ସେ ଘରକୁ ମନକୁ ଆସିବେ, ମୁଁ ଛୁଆଙ୍କୁ ଛାଡି ଯାଇପାରିବି ନାହିଁ। ତାପରେ ମୁଁ ଫେରି ଆସିବାରୁ ଶିବ ସାହୁ ମତେ କହିଲା ରମେଶ ବାରିକ ରାସ୍ତା କଡ଼େ ପଡିଛି, ଏଣୁ ତାକୁ ଟେକି ଧରି ମିଶିକରି ଜାମୁ ଗଛ ତଳେ ନେଇଯିବା। ମୁଁ ରମେଶ ବାରିକର 2 ହାତ ଧରିଲି ଓ ଶିବ ସାହୁ 2 ଗୋଡ଼ ଧରିଲା। ଆମେ ଦୁହେଁ ମିଶି ତାକୁ ଟେକି ଆଣି ଜାମୁ ଗଛ ତଳେ ଶୁଆଇ ଦେଲୁ। ସେତେବେଳେ ସେ ଲୋକଟି ବଞ୍ଚିଥିଲା ଓ ନିଶ୍ୱାସ ପ୍ରଶ୍ୱାସ ଘୁଡ଼ୁ କରୁଥିଲା। ତାପରେ ଶିବ ସାହୁ ସେ ଥିଲା। ମୁଁ ସେଠାରୁ ଆମ ଘରକୁ ଚାଲିଗଲି। ତା 31 ତାରିଖ ଦିନ ସକାଳୁ ଉଠି ଜାମୁ ଗଛ ନିକଟରେ ଗହଳି ଥିବା ଦେଖି ସେଠାକୁ ଯାଇ ଦେଖିଲି ଯେ ମୋ ମୈତ୍ର କାକା ରମେଶ ବାରିକ ସେଠାରେ ମରି ପଡିଥିଲା। This is the statement, my lord. And another statement, my lord, at page number 25, my lord.
You are Sibo Sahu, huh?
My lord.
There is nothing.
Nothing, my lord. And my lord,
That is the last in theory Miller. Then I am submitting Miller extrajudicial
And
confession.
when you have last seen, when he has last seen, that time this man was completely in a condition, he was sleeping outside since last 4 years.
Must be.
my lord, ତାପରେ ମୁଁ କହିଛି
He
ତାକୁ
was
ଯେ
in a
ଯାଇକିନା-
moribund condition at that place.
Huh?
He was in a moribund condition, my lord, at that time.
Completely inebriated state.
Then other evidence are there, my lord. Why same last in theory, son of the present petitioner stated that ମୋ ବାପା ଆଜି ରମେଶକୁ ଲାତ ବିଧା ଗୋଠା ମାରିଲା. That has been listened by one witness, Ganesh Barik, my lord. Then leading to discovery statement, my lord. He has admitted that
What discovery?
that ଉକ୍ତ ଦୁହେଁ ଜାମୁ ଗଛ ମୂଳେ ମୁଁ ତାକୁ ପିଇବା ପାଇଁ ମଦ ଦେଇଥିଲା ବେଳେ ଗ୍ଲାସରେ ମଦ ଦେଇଥିଲି. ତାପରେ ଉଭୟଙ୍କ ମଧ୍ୟରେ କଜିଆ ହେଲା ପରେ ରାତି ପ୍ରାୟ 9ଟା ଘଣ୍ଟା ବେଳେ ମୁଁ ତାକୁ ବିଧା ଉଠା ପାଇଁ ତଳେ ଶୁଆଇ ଦେଲି. ଉକ୍ତ ଷ୍ଟିଲ ଗ୍ଲାସକୁ ମୋ ଘର ବାଡ଼ି ବୁଦା ବେଳେ ରଖିଛି. ଗୋଟେ ଗ୍ଲାସ ପ୍ଲସ ଯାହା ଥିଲା ସେଥିରେ ମୁଣ୍ଡରେ ବାଡିଲା, ସେଟା ରିକଭରି ହେଲା.
have a glance to page.
And he has sustained 5 injuries in it. That is there.
5 injuries.
Yes, 5 injuries. 6 injuries.
Have a glance to page number 25, my lord. 25, my lord.
6 injuries. Huh?
Yes, 6 injuries.
But still, you have very weak evidence.
Yes, that is there.
Very weak evidence.
Miller.
Custody since?
Since, my lord, 6/9/2023.
Chargesheet filed on 14/9. There is no direct evidence, huh?
No.
No, that.
Right of petitioner. I am granting him bail.
Miller.
Petitioner is accused in so allegation against the petitioner. Okay. Chargesheet has been filed in urgent case on 14/9/2023. Petitioner is in custody since 6/9/2020. There is no direct evidence available in the present case. It is the petitioner is made an accused on the basis of last seen basis of the fact that he was lastly seen with the deceased. But the evidence indicates that at the time when the petitioner was in the company of the deceased was in inebriated condition. The wife of the deceased has disclosed that the deceased has been sleeping outside the house, outside there since last 2 days, and it appears he was also drunk. The deceased and deceased was drunk. And apart from that, there is no other evidence. The counsel for the state submits that on the basis of disclosure made by the present accused, recovery has been effected. There is no clear-cut evidence which is coming out as to whether the petitioner has used any weapons to assault the deceased, assaulted the deceased. In view of the aforementioned, and taking into consideration the period of custody, the petitioner is entitled for bail, and give the bail with the condition that the petitioner shall not intercept and shall not be in contact with any family member of the deceased. Violation of any condition will entail the cancellation of bail, and the prosecution is given liberty to move application before the court below in the event court below for cancellation of bail in the event violation of any condition imposed by the court or attempt made by the petitioner to influence any of the witnesses.
Yes, I may be pardoned. 74, the parties are present. The petitioners are the husband and the in-laws.
74.
14 adjust.
Nobody there.
Item 50.
Display working. None appears for the petitioner in the interest of justice and please.
51.
On behalf of Mr. Mohapatra, permitted to withdraw.
52.
May it please your lordship. Lordship, the present petitioner has been in custody since 6/1/2024. In the meantime, your lordship, charge sheet has been submitted under section 302 and 201. The present petitioner is the sole accused in the present case, your lordship. The allegation against the present petitioner is that?
Charge sheet filed?
Yes, your lordship.
When?
Charge sheet has been filed on 3/5/2024.
3/5.
Yes, your lordship.
3/5.
2024.
Go to trial court once again. Your bail application rejected 1/2/2020.
Yes, your lordship. But that would not serve any purpose since at the time of consideration of the bail before this honorable court, the materials had already been placed, your lordship.
That's right, but the trial court, you have to go to the court of first instance after the charge sheet is filed. I will record everything.
Your lordship.
Right
Your
up.
lordship may record that since the case is based on circumstantial evidence, your lordship.
And that the petitioner is agreed by the order dated 1/2/2024, whereby his bail passed by the ADJ cum Special Judge Vigilance Dhenkanal in BLAPL number 20 of 2024, where his bail application has been turned down. Subsequent to the impugn order, subsequent to the impugn order, the charge sheet has now been filed on 3/5/2024. During the period of investigation, and since during the period of investigation, the bail application was rejected and subsequently the charge sheet has been filed. I am of the view that the petitioner should approach the court below. Petitioner should approach the court of first instance. Let counsel for the petitioners submit that the case is one of there is no direct evidence available in the on record against the petitioner.
That is at page 16, your lordship.
Petitioner, except the circumstantial evidence.
Under section
Even
10.
this fact is illuminating from the charge sheet filed by the police. And liberty is granted to the petitioner to highlight those issues at the during the hearing of the bail plea before the trial court. With this observation, the petitioner is next.
54.
May I please? Mr. My lord, notice had gone to the opposite party number 2, written unserved. First time notice had gone to permanent address of the opposite party number 2 and written unserved. Thereafter, present address also written unserved. My lord.
What is the offense?
Pray with your lordship, directed the police to serve the notice, my lord.
No, what is the offense? What
My-
are you asking here?
My lord,
What are you asking? 1CC case, quashing.
Quashing of cognizance.
question of cognizance, my lord.
Cognizance order.
My lord,
Where
that
is
is-
that cognizance order?
29/8/22.
That is annexure 8, my lord, order of cognizance.
What is wrong in it?
My lord,
What is wrong in it? Tell me.
and this honorable court in its order dated,
You show me the complaint petition and the initial statement. If any case is made out. Cognizance is taken.
my lord, complaint
Show me
petition,
the
my
initial
lord,
statement.
that is, my lord, annexure 6, page 48, my lord.
6.
Annexure 6, page 48.
Yes.
In this matter, my lord, FIR lodged against all the petitioners, my lord. Thereafter, police submitted charge sheet only in the name of husband, my lord. Thereafter, the protest petition filed by the informant, my lord, and that is annexure 6, page 48. That is the complaint petition, my lord. Complaint petition filed under section 341, 366, 3762 N.
Show me the from the complaint petition, protest petition, allegations against these people. Which part? Come to page 52.
52 mail.
52 middle paragraph.
That in fact in June 2022.
In fact, in June 22, accused number 1 proposed the complainant to marry that she has rejected. And then at about 7 p.m. on such and such day, when the complainant was bringing water from the well to his house, the accused number 1, 2, and 3 came with the bike and forcibly kidnapped so and so, so and so. Thereafter, keep on reading all allegations. These allegations are there. And come to the statement. Come to the statement, initial statement under section 200. Para 3.
That is annexed 7, my lord.
Para 3. Page 54.
54.
Sushant Das, Gangadhar Das, New Das, so and so, all the names. Real accused persons of this case, and police had not recorded my statement properly. All these statements are there. Thereafter, he narrates everything against all of you. What is wrong in Cognizance?
In this matter, police examined all recorded statement of all the witnesses, my lord, and submitted
In a
charge sheet.
protest petition, if Cognizance is taken, the court only will see the protest petition and initial statement at 200. If any allegations are there, court has rightly taken.
This is a case of clearly consent, my lord. After marrying the informant, after marrying the petitioner number 2 to my lord, staying in his house for 6 months, and after 6 months, she fled away from the house of the.
That's framed.
No, my lord, it's called. They have come already in cognizance stage, madam.
You argue all these things.
At the time of framing charge.
Right.
Petitioner
is agreed by the order dated. Order dated 29/8/2022, passed by the learned JMFC, Chandabali.
Next week, next week, I will prepare.
221. Whereby the court below has taken cognizance of offense under section so and so against the petitioners. I have perused the copy of the complaint of the protest petition and the initial statement of the witnesses recorded under section 200 CRPC. There are specific allegations made against these petitioners, and which is reiterated by the witnesses in their statement under section 200.
200 and 202.
And 202. 202. Therefore, the court below has rightly taken cognizance of offense. Then, consequently, the petitioner submits that the cognizance has been wrongly taken under various sections. It's a case of consensual relationships, and the offenses are not made out.
Police submitted charge sheet only 490 A, my lord.
Offenses are not made out. In this case, offenses are not made out. At this stage of cognizance, this court is not willing to go into the details of the argument advanced by the petitioner to ascertain whether a particular offense is made out or not. Rather, the petitioner should argue all these points at the stage of framing of charges. Accordingly, this petition is disposed of for granting liberty to the petitioner to raise all these points at the stage of framing of charges. With this observation, the petition is given. Yes, next.
498 A रे police again charge sheet submit करजी. It a clear case of consent and marriage. The informant married to the
I have given-
after marriage she leave also.
I have given you liberty to argue all these things point before the trial court at the time of framing of charges. I can't go into one offense or two offenses. I have to see these two document if a case is made out, the case is not made out, they are not made out.
This
What
honorable,
about that one?
this honorable court in first order directed this till the appearance of informant. My lord,
Maybe trying to settle the dispute if she is not coming forward, what to do? Next. 55.
55, my lord. This is case for quashing of affair, my lord. In the meantime, charge sheet has already submitted, my lord. Mr. Das earlier occasion arguing before this 3 to 4 occasion, my lord, stated that charge sheet has not been submitted, but in the meantime, charge sheet has already been submitted.
Charge sheet has been submitted. Huh?
Submitted on 16/3/2024. And all the allegations are, my lord, the charge sheet for 294, 427.
None appears for the petition. The present petition, in the present petition, petitioner is seeking quashing of the FIR, and the petition was filed at the during the when the matter was being investigated. And charge sheet, Mr. Raghunath appears for the state and submits that charge sheet has been filed on
16/3/2024.
16/3/2024. Since charge sheet has already been filed, I'm not willing to inclined to entertain this petition. Therefore, the petition is disposed of. We negotiate to the petitioner to avail remedy under law. Yes. 56.
56 a modification of order, my lord.
Which order?
Order dated, my lord, 23 to 2024, my lord. Here, my lord,
which part?
Part, my lord, the case has been now transferred to the court of law and JMFC juvenile court by JJR case number 18/23, my lord.
Which part you want correction?
Part, my lord, second paragraph, my lord. That court is that has been written as Balugam case so corresponding GR case number 315 of 2020 pending in the court of London JMFC Chilika. And the case has been transferred to the court of, my lord, JMFC juvenile court by JJR case number 18/2023.
Give in writing. Change for to court the order dated 20th March 2024. Change give in writing what?
Yes, my lord. And my lord, another I have your lordship directed parity for dispose of the bail application on the same day. Only
don't on modification don't add.
Your lordship has directed for parity.
Next item.
Your lordship has directed for parity for dispose of on the same day. Simple.
No, I will not add anything. Modification, if there is a correction, I will correct it. Not that in the name of modification you come and try to add things in the order.
That is for on
that is there. If that is there, that is there. Same order will remain. Only wherever there is a typographical error, I will correct it.
Yes.
In the name of correction, you are moving an application and asking to add something on the order.
Your lordship has got surrender before the court will and parity. My only on the same day.
That's what I'm saying. I can't add it.
Lordship only that.
I can't add something on the order because you are asking for modification. Typographical error. I have corrected that part. Allowed. The application is allowed. Correction carried out. Yes. Yes.
I'll just remind I'll just remind my lords with reference to 2-3 previous orders here. In fact, it's a fit case for quashing. Lordship may kindly see it's in a very nutshell and quickly what is the issue is. Accident took place in the blast furnace of the factory.
Yes.
A person died. Say fire accident in the blast furnace of a factory.
Yes.
And one worker died. See, 5-6 persons, they have lost affair. Against the factory officials, they have included the name of the CFO, Chief Finance Officer. Chief Finance Officer is a position which is absolutely unconnected with the technical part of the factory.
You are the chief.
I am the Chief Finance Officer. Now, your lordship will see there are 3 orders passed by my lords previously. Yes. One is order dated 21st of November 23, passed by the coordinate bench of this honorable court.
Yes.
With regard to the Factories Act, the preliminary inquiry. If there is an accident in the inquiry under the Factories Act, there has to be a preliminary inquiry. Who is responsible for this by the Inspector of Boilers? Lord, this order was passed on 1st of November 23, order number 1. Then also it was reiterated on 7th of December 23. Then my lords also passed order on 8th of January.
Preliminary inquiry something.
They have submitted.
My lord, preliminary inquiry report, my lord, at fact C, but my senior my lord filed an additional affidavit, my lord. I have to give
That's not required. I am not arguing on that. I am not going to additional affidavit. Let me argue on your report, please. I have to linger for
Yes.
Now, my lord, kindly see that this person to my lord's order, they have produced that preliminary inquiry report. Flag C, man. Kindly see flag C. This report, entire report, if your lordship kindly have a glance over this. Is it there before my lords?
Yes.
Flag C. Kindly see, but there is absolutely no attribution against the petitioner. There is absolutely no attribution connecting this petitioner in the report. That my learned friend will agree.
That is true, my lord.
That is, then kindly, 1 second, kindly. The next your lordship may see what is suggested in para 17. One more interesting part is there.
Para 17 of what?
This preliminary inquiry report.
Yes.
Violation of provisions of Factories Act and Odisha Factories Rules, giving justification as regards to lapses shortcomings from the incident described above, management violated 62D, Rule 62H of Odisha Factories Rules. This is in fact is relevant. In a factory, if an accident takes place, it is governed under the Factories Act. If my lords see section 93 of Factories Act, there is a provision of penalty and other penal actions. That says that inspector of broilers will conduct an inquiry and punish the persons responsible.
What are the offense alleged?
But these offenses cannot be made out. It's an accident in the factory. It has to be governed under Factories Act. Section 105 says no court will take cognizance unless.
Charge sheet filed under which provision?
Charge sheet has not yet been filed. The FIR is 304A, 307.
285, 286, 337.
These offenses.
When are you going to file charge sheet?
For that I need 1 week time, my lord. So that
And if your inspecting report says it is a violation of the
Factories Act and Rules.
62D and H
Yes.
of the Factories Act. We are pursuing IPC offenses.
Yes. This is not permissible. That is one.
For that time needs one week time, my lord.
You have rightly pointed out in right time. Then wait for the charge sheet. They may.
But charge sheet will not, because I am a person, I should not even undergo an investigation. The reason being, if a lordship sees section 105, there cannot be a complaint without a complaint being lodged by the inspector of factories. What to speak about the FIR by some private person?
But the FIR is 304.
304A.
So therefore, for that,
so 304.
If you say that it is Factories Act, then only
section 9.
So FIR is 304A. So there must be allegation concerning the petitioner in the FIR or in anywhere in the incriminating material, if accepting the FIR as it is. 304A and other allied offenses. Finance officer, not there is absolute no allegation against the petitioner. That your lordship examined last date, man. Lordship may kindly see. But finance officer dealing with finance has absolutely no. Sibo Sankar Mishra says the case can be quashed at this stage also.
All IPC offenses 30.
And without any allegation against the petitioner. There must be specific allegation against the petitioner.
Have you got anything? 161 any?
161 is there, my lord. But in fact, I have to take instruction, my lord. And
with
against this, he is a finance officer. Nothing to do with technicality.
But the question is, if there are, my lord, Factories Act special statute, my lord. This is under general law, my lord.
No.
Whether it will
leave that
it will run or section 92 will prevail, my lord.
No,
that is the question,
some
my lord.
extent has
For
taken.
that reason, my lord.
1 minute. Some extent has taken place in the factory. Technical people will be obviously liable for that. A account officer who is sitting in the office, how will you pay him?
That is the, my lord, one thing, my lord, one part, my lord. But the law is, my lord, whether this general law will prevail or the special
I am
law.
not on that. I am saying IPC.
We are not on that. Yes.
Forget about-
my lord.
What I am saying is IPC offense. I am testing the IPC offense.
Yes,
Forget
yes,
about that,
yes,
that part.
Yes, yes.
That inspecting report and all, leave away.
Yes.
Even if it is your IPC offense,
IPC.
which offense you can attract to a
Against the
finance
petitioner.
officer
What is the allegation?
who is sitting in the
role played by the petitioner.
For that reason, my lord, I have called.
You have taken time last occasion also.
My friend was there, my lord. Since stage operating, my lord.
No, there is no stay order. No stay order is there.
last and final opportunity. Get it. Because see, He's a finance guy. He
check,
must be sitting somewhere in the office.
Call him, but he is unable to come, my lord, today. That's okay, I will file the reply.
Okay, let us accommodate 1 week. Last and final opportunity. Eh?
Yes.
He test
Madam,
that.
I know.
The factory, keep aside that factory part. Factory part is a different thing. Don't get into the technicality. The FIR as it is, you take it.
Yes, yes.
If you take it FIR as it is, how can you bring in a 304A case
Against a finance
rash
officer?
and negligent
Madam.
act?
Uh-huh.
A finance officer sitting in the office, how can he?
My learned friend has that much of acumen to examine that, I know.
Title of the owner of the factory matches with the finance officer or what?
No. That will be,
That
then
must
I'll
the
be
reason.
elevated to that position.
I'm
I'll be really proud of that.
I'm just yes. What is your name? By the name is?
Name is
Kejriwal.
Kejriwal.
Oh, the name is
That
dangerous.
name is
That
attractive.
may be the reason.
Name is
Anyway.
the name is the reason.
Name is the reason. Get some.
Madam.
Yes.
48, my lord. My humble apology, my lord. The defects has not been removed as there is some defect in the FIR copy. My lord, the petitioner will hand over the new FIR copy to us. So, my lord.
On 2nd August, you took time. That
Okay,
time you will cure the defect. You didn't cure. 2 working days. 2 working days you have to cure the defect.
Obliged,
In the event you don't cure the defect, it will be automatically dismissed without reference to the court.
Obliged, ma'am.
Right.
I took note 15
Within
days.
2 working days. On 2/8/2024, the counsel for the petitioner had sought time for curing the defect, but the defects have not been cured. The counsel for the petitioner submits that she would be curing the defect within 2 working days. If defects are not cured within 2 working days, the petition would be dismissed without reference to the court. If the defects are cured, then list the matter for hearing on after 2 weeks. Yes.
Obliged, ma'am.
My lord, the petitioner's 205 petition has been rejected by the JMFC Narsinghapur, my lord.
205.
My lord, in a proceeding under section 138 of NI Act, my lord. My lord, the petitioner is a serious neurological problem. My lord, answer 3 is the prescriptions, doctor prescriptions, my lord. Is under treatment in different hospitals.
Let me issue notice to the opposite party. Issue notice to opposite party. What is the check amount?
75,000.
Why don't you give an installment?
My lord, there is a at the time he was a civil contractor, my lord.
My
And
lord,
the opposite
check you have
party
given
is a
to
partner, my
my
lord.
lord, may I
Between
submit
them-
one thing? In this case, my lord, earlier in another CRLMC, 1947 of 2023, the
My lord, that
Sir,
was a
that has been disposed of by
disposed of with a
Chief-
direction.
Honorable, let me say, by
Direction.
the Honorable Chief Justice, like such, that it is the present petition has been filed with the following prayer. It is therefore prayer that this Honorable Court may graciously be pleased to admit the application called for the record, and after hearing the parties, the order dated 3/2/23, passed by the Lord JMFC Narsinghpur in the IAC case number so and so, Annexed 3 be set aside quashed in the interest of justice.
What is
And to any other
No,
consideration.
that's right. What is Annex 3?
Yeah, my lord.
What
it
was
is
that petition?
No, my lord. Thereafter, I raised the petition, raised the plea at the court below, my lord. Thereafter, after rejection, I filed this
First
petition.
you filed 205, which is rejected.
Rejected.
Thereafter you came to this court.
My lord.
Again rejected. Thereafter again you moved
No, my lord.
205.
My lord,
Rejected again you.
And
Is
your
the
lordship may
Honorable
kindly
Court
have a glance.
prohibiting the petitioner to raise all the pleas caused by the present petition before the trial court. Thereafter, I filed the petition.
Where is
in
that
the-
order? Where is that?
Your lordship only kindly have a glance at the running page of 14, my lord. After giving the chance to the petitioner, my lord, but intentionally he is avoiding to the court process.
Where
As
is
per the order, my lord, page number 14, my lord, your lordship may kindly have
Page
glance.
14.
Page
of
number
this
14,
petition.
the order of the court below, my lord.
Where is it? Item? Annexure?
My lord is
13 last para and 14 page.
Annexure, huh?
serious neurological problem, my lord. The petitioner, my lord, said now he is admitting at a Nimans Hospital, Bangalore, my lord, and he is unable to attend the court, my lord. Therefore,
In middle part, my lord.
It's all right. It is a 138
Yes, ma'am. Yes,
138/205 is allowed
yes, ma'am.
invariably, and he is a patient. So 75,000 rupees check. You
Yes,
should
my lord, your
better.
lordship.
You should, instead of wasting time coming to High Court many times, you should have paid by that time. You might have spent about more than the check amount by prosecuting. I don't know why. Who is advising? Will you pay it? I'll persuade the other side and close the case. Quash it.
and notice
It's a matter of 75,000. You are coming to the High Court twice. You have come. Unnecessary wasting time. Write an issue notice to the opposite party. Written within 1 week. Come with the some money. I'll pay on installment basis. I'll quash it.
Ma'am.
Okay. Persuade your client to come with money. Yes.
No court action. Miscase.
What court action? 138 meter. What court action? You have not asked for a cancellation of NBW.
My lord, miscase, my lord.
Huh? Where is that?
My lord.
The NBW issued against the petitioner, execution of NBW issued by the court below by the order dated
15/12/2022.
15/12/2022 shall be kept in abeyance till next date of hearing. Next, yes.
Item 16.
FIR on the ground of compromise, my lord.
Offense?
Register under section 376, but the fact is like that, my lord.
No, don't tell me the fact. 376 is not POCSO, is there?
No POCSO.
Then you can settle what is the problem.
No, my
Where is
lord,
that?
this case is like that, that the.
Have you settled or not?
Yes, my lord.
Why are you speaking about merit? Call that lady.
My lord,
I'll quash it.
Your lordship may kindly fix to 16th, my lord.
Petitioner is seeking quashing of for the FIR number so and so under section so and so on the ground that the parties have settled their issues. However, neither the joint affidavit filed?
Separate affidavit filed. That is all
However, the
filed.
party, although the parties have filed separate affidavit regarding the settlement, however, none of them are present in the court. Release the matter on such. Yes.
61.
Next week, yes.
61.
All them.
This is regarding the quashing of the second FIR. First FIR was filed by the NSR 1, your lordship. And second FIR, first FIR was filed by the brother of the accused, my lord.
302.
My lord, 302.
Quashing of 302 FIR.
Your lordship, second FIR. is concerned.
Second FIR under section?
Under section 498, 302, 498A and
302, how can I quash?
Where is the second FIR?
second FIR.
First FIR is page 12, my lord.
The second
Annex
FIR is
one.
also 302.
Yes, madam.
Well, Annex 2, he has stated that Annex 2 is the second. Is it a FIR, my lord? Annex 2, my lord.
Just see 302, second also.
My lord, Annex page 16, my lord.
Annex 3.
Annex 2, my lord, page
Annex
16.
2.
Page 16.
What? This is FIR under which provision?
This is also 302.
Oh, 302, how can I quash? Matter of. This is the petitioner is seeking quashing of FIR number. PS case
135.
number, PS Savalaya PS case number 135 of 2021 under section so. 302. Investigation is still going on?
The investigation completed.
First
filed.
case investigation completed.
Investigation has already been completed and charge sheet has been filed. Regarding that to the nature of allegation made against the petitioner and the evidence collected by the police and filed by form part of the charges, form part of the charges. I am not inclined to entertain this petition. Yes, next.
62.
May I please, my lords? Annexure 3, my lord, order of a cognizance challenge before lordships. Annexure 3, page 24, my lord.
Yes.
Offense under section 341, 323, 324, 326, 307, 506.
Don't read the sections.
My lord, this is the offense, my lords, where the petitioners, my lord, cognizance taken against him, for which he has filed this CRMC for passing, my lord.
Right.
My specific allegation, my lord, is that 307, my lord, specific allegation, 1026, not made out against the petitioner so far the is concerned, my lord. FIR I have filed annexure 1, that is the FIR lodged by
Your only argument is 307 should not have been there.
307 and the offense is not made out, my lord, my
Yeah.
specific. Other offenses, my lord,
Then what is the test? You should go to which court? Argument the charge 307 is not made out. You
Charge-
can't attack the cognizance order.
my lord, charge has not been framed, my lord.
Therefore, you should go and argue 307 is not made out. Don't frame the charge.
Now, if lordship, my lord,
This is the law.
I come here, before lordship, my lord, that if a prima facie satisfy lordship that these offenses are not made out,
necessarily.
why the petitioner will face the to frame charge will frame, thereafter trial will be, my lord, commence. If a lord is satisfied, my lord, I, my lord, this.
I need not satisfy. Just see the.
Yeah,
My lord, page 22, my lord, kindly see.
Just see the allegation.
wife of a injured my lord filed this FIR, annexure 1.
Whoever it is, there is prima facie material. And if you say that 307 is not made out, you have to go and argue that at the charge stage. Obviously, at the charge, you can't attack cognizance order like this.
I have filed my the cognizance order. Charge frame yet has been made or not, my lord, I have not, my lords. But at the time of filing, it charge was not made. In the meantime, my lord, the time has been passed, my lord, to more than it was filed December filed this CRMC, my lord, before this honorable court. In the mind, 80 months has passed. I have to take instruction, my lord, whether charge has been framed or not.
No, I will cover both. Right, and if the charge is framed, then you file revision against the charge.
No, yeah,
Charge is framed,
what
then,
develop?
in any case, your cognizance order goes. Charge is framed. If charge is not framed, you argue it. If charge is framed, file revision. Right now, a petitioner has challenged the order dated 26/9/2023, passed by the which court has
SDJM.
SDJM.
That is
SDJM PKD. What is PKD?
ADGM, Paralakham.
Whereby the cognizance of offense under section so taken against the petitioner. The learned counsel for the petitioner submits that even if the allegations made in the charge sheet is taken at its face value, no case under section 307 is made out against the petitioner. I am not inclined to entertain this petitioner at this stage.
Liberty नहीं जाऊँ तो
Arguments advanced by the petitioner would only be tested by the trial court at the time of framing of charges. Therefore, the petitioner at this stage, the petitioner seeks to withdraw this petition with the liberty to approach the court below at the appropriate stage. With this liberty, the petitioner is to next.
May appeal lordship. The present petition challenges the order dated 16/11/2022. Passed by Lord JMFC Rajgam, they have taken cognizance on 341, 323 and 75 of Juvenile Justice Act, my lord. The present petitioner is the teacher, my lord, and informant is the student, father of the student, my lord. There the allegation, the present petitioner asserted the student, my lord. Can see the page 12, my lord. The statement of his friend, my lord.
Yes.
गत 20/22 आम स्कूल कांथर लगी मुख्यमंत्री और अन्य हॉकी खेलाड़ी फटोरे रोहित मिज किसी भूल चित्र आंकबार आम हॉस्टेल वार्डन दिलीप कुमार सोरेन ସାର୍ ରାତି ପ୍ରାୟ 9:30 ସମୟରେ ହଷ୍ଟେଲ ବାହାରେ ରୋହିତକୁ କ'ଣ ପାଇଁ ଏମିତି କଲୁ ବହୁତ ଜୋରରେ ପିଟିଲୁ, ଯାହା ଫଳରେ ତା ଦେହରେ ଆଘାତ ଲାଗିଛି। ଗତକାଲି ତାଙ୍କ ଘର ଲୋକକୁ ଖବର ଦେବାରୁ କାଲି ତାଙ୍କ ଘର ଲୋକ ଆସି ତାକୁ ହଷ୍ଟେଲକୁ ନେଇଗଲେ। Similar statement also other students.
But then he has assaulted. That's the allegation.
He
The
has-
teacher has assaulted. Cognizance is taken. What to do?
That is not repeatedly, my lord. Once
Once is enough.
Assault
Once
part
also,
is
if
there.
you assault your student,
he has committed
FIR
some,
is lodged. The
He-
parents have lodged the FIR. What to do?
he has committed some mistakes.
Huh?
He has distributed some of the photographs of the
Whatever the student does, gone are those days when we people were studying. We used to get beaten up by our teachers. And if you go come and tell in your house, you will get, secondly, again you get beaten up by your parents. But now the situation is the reverse. What to do? But the offense is made up. Withdraw it and argue at the charge stage. Can't be.
Charge sheet submitted, my lord.
Charge sheet submitted.
Yes, challenge the Cognizance order.
Right, I know. Charge, you have to argue at the stage of charge.
Raise all the points.
Or you try and settle them with
Yes.
parents.
The informed is the opposite party to my lord. Can issue notice to him?
Let us issue notice at 323 and parents given complaint against the teacher.
Teacher. Or silly mistake, yes.
I'll issue notice.
My lord.
Issue notice. Issue notice.
Okay.
Yes.
64.
On behalf of Mr. GNSO, 1 week time may kindly be allowed removing defects.
If it's not cured, 1 week time is granted.
What is it?
The last of
2014 affair.
Huh?
2014 affair.
Okay.
There is for
Washing.
to quash the to quash the affair. And the allegation is that he has produced the fake +2 certificate.
What is the stage of the trial might have been concluded? 10 years. 2014 is the FIR. Today you are asking for quashing. What is the stage?
And
Except
that's it.
a copy of FIR, nothing is filed.
And my charge sheet was submitted since 2015.
That I have done. In this petitioner has filed and a petitioner has he is asking for quashing of FIR or entire proceeding. Annex 1. Petitioner is seeking quashing of FIR number so and so or dated 17/6/2020 2014.
No, 7/6/2014, madam.
7/6/2014.
Right.
14. After investigation, charge sheet in the present case has already been filed on
On 12/8/2015.
12/8/2015. I am not inclined to entertain the present petition seeking quashing of the FIR at the belated stage. Hence, the petition is dismissed with the liberty to the petitioner to raise all the points before the court below at the stage. Yes, next.
65.
That's our political, the point, the first point of the registry has also not been given. Yes. 60?
May I please, Your Lordship?
Yes.
Your Lordship, I have complied with the noting that shortage of postal stamp, Your Lordship, by today. So kindly notice may be issued, Your Lordship.
Once the interim order is passed, this is the whole difficulty.
Just one more.
Once you get the interim order, then first you don't file requisite, then you file short requisite. Thereafter, there is no stamp. All these
Your
tactics are
Lordship,
being employed.
No, second time requisite has been filed. Your Lordship. First time it has come as insufficient, Your Lordship. And second time we have filed the requisites actually due to some clerical mistake. I have not known
One
earlier.
mistake, if I'll vacate the stay, then there won't be any mistake at all.
Yes, yes.
Because
One
this
last
state,
point.
therefore, this is happening. This matter is pending since in 2023. This is regarding what?
Short time, Your Lordship.
This is regarding passing of what?
Cognizance order under section 436, Your Lordship.
Argue on merit
Your Lordship, kindly allow for a short time, Your Lordship.
tomorrow. Forget about anything. I am not satisfied that this petition is even entertainable.
Your Lordship, only notice
Merely
might be
because
returned.
the
Your
courts
Lordship.
are a little liberal doesn't mean that you take a stay and keep quiet for years to come.
No, it was
Huh?
genuine mistake, Your Lordship.
Day after tomorrow. Day after tomorrow.
Kindly allow for at least
Do
2
whatever
weeks, Your
on merit
Lordship.
you get ready.
May I lordship, please?
Because of this kind of situation only, I am not granting by interim order.
Pardon me, Lordship, but it was a
What
genuine
pardon?
mistake.
Every time, sorry, pardon will not help. Why have you not done twice? You have taken 1 year back, you have taken stay and you are not filing process fee, correct process fee.
Actually, we are not able to have the knowledge regarding the postal stamp.
Yes, next.
66. May I lordship, please? I am on behalf of Lalit Sahu. My lord, it is a modification of order on dated 27/6/24.
Yes, what modification?
Modification order, my lord. The Honorable Court, the 27/6/24, the before the 15th July 24, and avail the remedy under law. But my lord, 307 offense, JMFC, the case is pending, JMFC Loisinga, Balangir. So 307, no power, my lord, JMFC.
What I have written, just see. I have written code below. I have not written any.
Pending, my lord, code below, but the case is pending, JMFC Loisinga.
That is code below.
But 307 and not no power to release on bail.
I don't know that. NVW cancel. I told that you go and appear before court below, seek remedy under law. I have not even written the name of the court. You go whichever is the court.
No, but the case is pending. JMFC, my lord.
What can I do? Court below, you go and move application. That's
but
what.
307 and no power, JMFC to release on bail. It is session power.
I have to give the power under 482.
No, my lord.
Then
first of second. First of second, I am ready to surrender, but only
see,
first of.
first you came here asking question against the NBW. I gave you that relief. Okay.
My lord.
And I don't know whether you deposited that cost of 500 or not. I don't know.
No, I am deposited.
Okay. Thereafter you moved,
I am deposited.
Thereafter you moved in a extension application. I gave extension. And now third application.
Third application, 27/6 order, JMFC no power. Only first of second of.
By way of this modification application, petitioner is seeking additional direction over and above the directions in the main petition. Therefore, the modification is not maintainable. The application is turned down. Yes.
67.
May I please, Your Lordship? Lordship, there has been 2 IAs filed in this case for setting aside of the abatement and under section 5 of the Limitation Act, Lordship.
Before that,
whole appellant died.
My lords, the moot question that your lordship has raised in the last occasion is whether basing on section 5 limitation, where there is inordinate delay, whether it can be dismissed on that ground or not. Pursuant to that, my lords, 2 judgments were filed by the learned senior.
Yes.
One is, my lords,
yes.
Harnam Singh versus State of Himachal Pradesh. It's a 1971 judgment. Even, my lords, in this judgment, my lords,
yes.
At para 17, your lordship may have a glance to para 17. 17, my lords, 17.
Yes. Yes.
My lords, this matter was dealt pursuant to the old CRPC. This is 71 judgment.
What does it say?
What does it say, my lords? An amendment to section 431. This is, my lords, regarding the old CRPC. An amendment to section 431 was suggested in the bill introduced in the parliament by a private member, Shri K.V. Raghunatha Reddy. The main object of the amendment was to provide a machinery whereby the children or the members of the family of a convicted person who dies during the appeal could challenge the conviction and get rid of the odium attaching to the family as a result of the conviction. Then, my lords, the Law Commission of India, by its 41st report, found the proposed amendment eminently sound and recommended that the amendment be made with certain modifications, my lords. Then they say, according to section 394 of CRPC, 1973 has been made a provision that where the appeal is against a conviction and sentence of death or of imprisonment.
What do you want to say?
I want to say, my lords, the mechanism regarding section 5 limitation has been dealt in this judgment also. My lords, I'm just reading the last two lines, that is important. That they have provided the mechanism, my lords. Accordingly, section 394 of the CRPC 1973 has made a provision that where the appeal is against a conviction and sentence of death or of imprisonment, and the appellant dies during the pendency of the appeal, any of his near relatives may, within 30 days of the death of the appellant, apply to the appellate court for leave to continue the appeal. It's also provided here, my lords.
That in the statute itself,
Statute itself is
within
there.
30 days you move.
Yes, my lords. In the last occasion, what my learned senior wants to canvass is that the provision given under 394 has no importance. This is what he wanted to substantiate, basing on these two judgments.
No, Lordship. The question was framed, Lordship, when a composite punishment is there, where there is imprisonment and there is fine, the Lordship, this judgment covers that. In paragraph 10, Lordship, it is written that the narrow question which then requires to be considered is whether an appeal.
Para 10.
Yes, Your Lordship, of the same judgment, Har Naam Singh.
My lords, the moot question was regarding the limitation aspect. This is always clear, my lord. Where there is a composite sentence of fine and conviction, then abatement has to, substitution has to be there.
My question is, since 30 days is
yes, my lord. That was the pertinent question.
And whether inordinate
delay. Yes, on that ground, whether it can be dismissed or abated or not. Yes, that was the question.
That was the question. You have any judgment?
My lords, I was relying on Balwant Singh judgment, my lords.
What does it say?
My lords, we kindly have a look at it. I am referring to 2010 8 SCC 685. Balwant Singh.
Within 30 days, if the application is not moved, it can't be abated.
Yes.
Okay. Thereafter, if somebody comes after 5 years, 6 years.
Yes, whether it is permissible or not. Yes.
That is the only.
Yes, that was the moot question, my lord.
Yes.
Now, here is a case, my lord. This case. Here the delay was 778 days. Then your lordship may kindly come to para 32 to para 32. Page 698, my lord. Page 698, para 32.
Yes.
Well, before that, I would like to say that this was regarding Order 22, Rule 9, my lords. But
that is the Order 22, Rule 9 and Rule 22 is a different this thing. This
yes.
Is see, so far as this why 394 is introduced in the CRPC.
Well,
if the stigma there,
the odium matters. Yes.
Only to eradicate that stigma, yes. They can continue the appeal.
Yes.
If after 5 years or 6 years or 10 years, that the stigma goes, stigma remains.
Yes.
Suppose the grandchild comes, somebody says that your grandfather was convicted in a rape case. He will find out, yes, he is convicted. Appeal was pending and by that time he died and it is abated.
Yes.
Can you prevent that grandchild to move an application saying that I will see that my grandfather should be honorably acquitted? He'll continue the appeal. Can you stop it?
We cannot stop, my lords. But
that is the question.
That has to go in accordance with the statute. Statute provides a mechanism that 30 days is that time, my lords.
30 days, till 30 days, the appeal survives. After 30 days, the appeal abates.
Yes.
From the date of when an appellant dies, till 30 days, that appeal cannot be touched. After 30 days, it abates.
Yes.
And after 30 days, when you can move under application under 394, it's silent.
Yes.
Silent. Now the question is, after somebody comes after 5 years or 6
yes,
years,
my lords, whether that will be entertained or not.
394 can be allowed or not.
Yes.
That's the question.
Yes.
Answer you find out.
Especially on inordinate delays, my lord.
Inordinate.
Yes.
Inordinate.
Inordinate.
You order 22 will not help you.
Well, there in that case, they have discussed the scope of section 5 of the limitation.
Because
in
these are
detail.
civil rights. See, order 22 and all, there are civil rights.
Because now the petitions are
Civil right get extinguished after a certain period of limitation. Because your right to even if you have a decree, you have to get it executed within period. So civil rights survives for a particular time.
Yes.
But these are the rights because
because
of the
here
stigma
when
attached to a conviction.
As in 394 provision, they are filing limitation petition pursuant to section 5 of the Limitation Act. Here in this case, they have discussed in detail the scope and limitations of section 5. That is the thing I want to question.
According to me, limitation for application is also not required. After 30 days, it abates.
Yes.
Where is the limitation prescribed? Where is the limitation prescribed?
As the provision
Why
provides-
should section 5 is required at all? That's the case. That is the case. Find out. According to me, that I may be wrong, but according to me, even section 5 is not required. 394 application can be moved anytime. Because it is regarding the stigma attached to the conviction of your relatives, your parents, or whoever it is.
So, my lords, in that case, with due respect, they can come up at any
Suppose
time.
imagine a situation, somebody is convicted for 302 or something. A grandchild or grandchild married to a woman, and they say that you have married in a family where your grandfather was convicted, whether that women who he married, newly introduced in the family, will be interested to wash away that stigma. He wants to move an application. What will happen? Can you stop it? Here. Merely you say that you are not even a family member at the time of the conviction. So you can't move. That is not the situation. You have to, look to the provision. Provision says you can. Find out.
I will find out.
Last time also you got that Postmaster General. Postmaster General.
That is very difficult judgment as far as the government is concerned.
Government. I will allow this application till it is both the applications allowed. Yes. Amended memo parties you file, huh?
As far as delay is concerned, my objection may kindly be formal objection in delay because it's an inordinate delay. It's
inordinate delay. Yes. Both the 68. Till this is kept open, you can find out some judgment and
68, my lords, may be taken up 1 week after, my lords. Mr. Srimanta Das is not well. He has broken his leg. And
Srimanta Das. Yes. 69.
Please, your lordship. हाँ हाँ अब क्या कर मुंह पर अच्छे हाँ अब क्या
Yes.
आप कौन मुंह पर हम किसको
नहीं महेंद्र महापात्र
हाँ he is also Mahendra Mahapatra. That's he thinks he is amicus curiae in this case.
Last time I was taken.
You have given copy to whom?
I've taken all the through pen drive.
Then you start writing 1, 2 or whatever.
Copy from the.
Then let him argue.
You have prepared.
Yes.
Have you prepared?
Yes.
You have also prepared.
Yes.
You be there. You can add something if he is prepared.
Yes.
Yes. You just identify yourself, Mahendra.
Myself, Mahendra Kumar Mohapatra.
He is also Mahendra Kumar Mohapatra.
Well, I was.
It's all right. No problem. No problem, ma'am.
Mahendra to MO. Myself,
You must distinguish your name.
One, two, or one. His name is Mohendra, MOHENDRA. Myself is MAHENDRA. Well, in this case, my lord, petitioner challenging the judgment order passed by the Lawrence Session Judge Fulbani, that is on
17th March, my lord, 2015. And yes, appeal case number
Who is the very
2015.
first state? Are you ready? Ready? Offense?
Offense under section 406 is a convicted 2 years and 3 months, my lord.
What happened in
And
appeal?
5,000 fine, my lord.
Appeal?
Well, my humble submission is brief fact of the case. On 9th August 2009, my lord, one Asit Mishra given gold ornament to the petitioner. Instead of that, in this mortgage, he is receiving 30,000 from the petitioner. On 13th December, informant saying that he is sending 34,000 to the petitioner, and that through his friend, namely Badrinaran Mishra. But my lord, petitioner not returning the 36 gram of gold chain to the petitioner, it is the allegation. Well, 22/6/2010, informant met to the present petitioner and demanding his gold chain, and he is not given, and scolded him slang, and he's saying that I will murder you. But my lord, on same day, the informant lodged an affair before the Fulbari PS, and case same day, the IIC registered under section 420, 406, 341, 323, 294, 506, and 34 IPC. Well, after facing trial, the present petitioner convicted under section 406, that is rigorous imprisonment for 2 years and 5,000, and in default, fine undergo 3 months rigorous imprisonment. Petitioner challenging the order JMFC before the London Sessions Judge, Fulbani, and
you tell me who are the witnesses. I understand.
Say,
Well,
PW1 is the informant in this
the
case.
allegation is he has mortgaged the gold ornament
Gold
for
ornament.
30,000 rupees.
Sir.
And the understanding was once the money is paid back along with interest, it has to be returned back.
Yes,
The
madam.
gold has to
Yes.
be returned back.
Yes, sir.
He said that 34,000 I paid. That
Yes,
is
sir.
along with interest.
That-
And he is not returning my gold. That's the whole
That is
allegation.
the case.
And when he asked for a loan, and he threatened and threatened to kill him and all.
Yes,
On
sir.
that basis, FIR is registered.
Sir.
How many witnesses are examined? What had happened? You tell me.
11
He was
witnesses
convicted
are-
under 406.
Well, 11 witnesses are examined.
Who are the relevant witnesses? You tell me.
PW 2, 5, 6, and 8 are declined
Who are they?
hostile. Declined hostile, my lord.
PW1 is the informant.
PW1 is the informant.
Yes.
And PW 3, 4, 7 have no knowledge about the case.
Then
Declined.
Then conviction is on the basis of PW1.
PW1 is saying that he is taking money 30,000 from the petitioner and given gold ornament 2 chain to him. But well, in his cross examination, at the time of cross examination, he is saying that he is taking 20,000 from him, and thereafter someday he is getting 10,000 by check. But my lord, PW11 is the one lodging owner. My lord, he is the interested witness, and he is saying that he has not seen the any gold ornament, or he is not knowledge about the gold ornament, and he knows he only knows he is given 30,000.
Yes.
But my lord, in this case, who has returned the 34,000 is not examined, my lord. Also, his mother, informant says that that gold ornament of his mother, but his mother is not examined in this case, my lord. My humble submission is that after 6 months he is coming to him and demanding gold ornament. It is not the good sin of the law. I'm saying that my humble submission is not, my lord, the actually gold ornament has given or not, it is not found in this case. My humble submission is not wants to return his money, hence his file this false and fabricated case before the court, and after trial, even if after trial it is not proved that he is given some gold ornament to him. Hence, my lord, 406 may kindly be.
Yes.
May kindly be acquitted.
Yes, yes, Mr. Mahapatra, you want to add anything? Let him out. He is MAK.
There is a case, Your Lordship. The conviction based on only 2 witnesses, Your Lordship.
1 and 11.
1 and 11.
Right.
Other will become hostile, Your Lordship. No seizure was made. The article belongs to the informant's mother. She was not been examined. It is the case of the difference that the informant asked for a loan, friendly loan. So I gave him check of rupees 10,000. And that was established by the IO, Your Lordship, that the informant deposited a check of rupees 10,000, which was debited from the appellant's account, Your Lordship. And moreover, Lordship, there is a discrepancy in the FIR as well as the deposition of the informant, Your Lordship.
Who is 11?
11 is the IO, Your Lordship.
No, my lord.
10 is
10,
11 is the.
Sorry, 10, Your Lordship.
10 is
And the case of the informant, he returned the money through one of his friend to the appellant, Your Lordship, rupees of 34,000. That person was never examined by the court below, Your Lordship, who returned the money to the appellant, Your Lordship. It's a case of that he died during the course of trial. And other witnesses, they become hostile, and it is categorically stated by them before the court that on being pressurized by the police, they deposed before the magistrate under 164 CRPC. The statement was recorded under 164 CRPC. And Lordship, there is no entrustment of that property, no property was recovered or seized. And the appellant was running a computer shop, and the informant was a contractor, Your Lordship. Only on basis, and there are 2 IOs, PW9, who conducted an investigation, and PW10 who filed the charge sheet.
Now the whole question is why should the PW1 and 11 version to be
PW1 is an interested witness, Your Lord.
One is interested.
He is the informant, Your Lord.
Yes. Who is 11?
11 is
another
Who is he? Villager?
No, 11 is the one lodging owner where informant was staying regularly in his lodge. When he comes to the Fulbani, he is not belongs to Fulbani, he is outside of the Fulbani.
And he is also interested. Yes. What do you have? Any material?
Actually, that is the difficulty because the contradictory statement they have made in the cross
I don't think there is anything.
Yes.
In the FIR he has stated that ମୁଁ ବାରମ୍ବାର ଯାଉଥିଲି ପଇସା ମାଗିବା ପାଇଁ. I visited Fulbani.
Except the 10,000.
PW11 was used to come and stay in the same hotel. Same hotel where he is the owner of the hotel.
Yes.
The informant used to come and stay in that hotel.
Regularly staying.
So he is interested witness.
Except that is
planted witness. The main witnesses have not supported.
Yes. Except the 10,000 check which has been transferred to the
30,000 given, that there is no proof. 34,000 given, that Badri Mishra gave. Badri Mishra is not examined. What else? The gold ornament which was mortgage belongs to the mother of the informant. She is also not examined. Was not. There is nothing.
There is no any receipt of the gold
FIR
ornament.
ବାରମ୍ବାର ଯାଉଥିଲି in his deposition before the court below ସେ କହୁଛି in para 11 it is a fact that after 9/8/2009 I have never been to Fulbani in the
Short note taken there. Judgment taken. I couldn't short note.
my learned friend will
You give, he has argued.
If your lordship permits, my lord, Mr. Patra is distinguishable. Though they bear the same name, but our Mahapatra is absolutely distinguishable.
Then you suggest that whenever I'll appoint Mahapatra, either of Mahapatra is taking the photograph.
Well, we are friends, my lord. There is no any discrepancy, my lord.
Yes.
Well, I have-
All hearing. All hearing matters. And he'll adjust the date because all hearing matters, he'll adjust.
Yes.
Okay.
No.